Item note 3 and 4, my lord. Actually, I'm not well, my lord, from last night, my lord. My consider of my senior friend, my lord. My lord, this is another date, my lord. This, my senior friend proposed, my lord, on 2nd of April, my lord. This only related to one point, my lord, section 34, my lord, on land acquisition, whether zero value of the land, my lord. Initially, that may be that is the question, my lord. Only.
That we have seen,
My lord.
don't find much case for interference.
My lord, I'll
2nd of April, at the request of the concept of the
Union of India. Union of India.
Union of India raised these matters on 2nd of April.
let
3 and 4.
Item number 16 and 17, there are two appeals against the same judgment. One by the state and the other by the private respondent. I've taken the consent of the other side, manner. I've got some difficulty today. Can it be fixed on 2nd of April?
Have you informed the
Yes, we have taken rather their consent.
2nd of April?
David.
Please, okay. I'm from item number 7, my lord.
Yes.
This was the matter of West Bengal, my lord. This one I have instruction, my lord.
Matter of
This is the matter of Kolkata regions, my lord. The matter will be transferred from Guwahati Airport.
What is it?
Kolkata region. What do you mean by Kolkata region?
The matter was related, my lord.
Matter was?
Related to Kolkata region, my lord. I have the instruction, my lord.
How?
Technically correct.
Let the matter comes, we'll consider.
After Bihu, my lord.
Please wait for your turn.
Lordship, in item number 1, my lord, we have filed the rejoinder affidavit against the affidavit in opposition filed by the respondent only to the extent, my lord, because we have deposited the amount and they have clearly denied the same. Only to that extent, I have filed the affidavit in reply, my lord. And
After a week,
Lordship,
at the request of land council for the petitioner list after a week.
Lordship,
Allow the affidavit in reply.
Lordship.
And land council for the petitioner has submitted that they have filed an.
I have received the copy.
Yes,
They have filed an additional affidavit.
Uh,
Or the same is not available. When you have filed,
yesterday, my lord.
how the same is not on record, list after a week. While taking the additional affidavit filed on behalf of the petitioner along with the red petition.
Rejoinder affidavit, Lordship,
Actually, rejoinder.
Rejoin them.
my lord,
Rejoinder.
Lordship, obliged, man.
May I please, lordship? If I can mention for listing, lordship, on appeal, lordship. Yesterday I have filing number 2825/2024 for tomorrow, lordship.
But tomorrow, what's the
Tomorrow.
urgency in that?
Urgency, lordship, after filing the writ petition,
Tuesday.
interim.
Tuesday.
I'm obliged.
Daily list for admission item 2.
similar, wait, please, your lordship, was it a similar repetition is pending and pending and his next date is fixed on 14th of March, your lordship. And there is an order, lordship, after the repetition, lordship, this appeal may be taken up, lordship.
Order is of 10-5.
Writ petition is pending. Yes, lordship. So how this writ petition might be pending before the single bench? Yes, lordship, but the issues, because the lordship ordered it at 10/5/2023, lordship. Of the appeal. Lordship, it shows that lordship.
ये analogous repeat.
We can consider the appellant has submitted that another writ petition being WPC 8024/2022 referred on behalf of the petitioner has not been decided. Has not been decided till date. Therefore, this writ appeal be adjourned in view of the observations made by this court on 10/5/2023. Just after 10 weeks.
The other writ petition is preferred by your client.
We have prepared, my lord.
It is for lordship. Preferred by the respondent,
Respondent number 6, my lord.
not petitioner, respondent number 6 is. Instead of 10 weeks, lordship, can it be like that, lordship? Instead of 10 weeks, lordship, can it be like that if we are allowed to mention after the repetition is over? That after 10 weeks, you gave, court has already ordered for already. Lordship, make a request before the land. Lordship, lordship.
Item number 5.
Lordship, here we, they have filed, as per the last order, lordship, they have filed the status report to your lordship. What happened? Have you filed? What is that?
37.
Lordship, it's the pink,
NHPC, who is the counsel for NHPC?
the pink flag, lordship, the pink flag.
437 page number.
Page number 437, my lord.
Lordship, may I pray for timing of this matter, your lordship, for some time, your lordship? They have,
My lord, the original is in Hindi. We have also given the English translation. It is at page 449. The original.
More than 70%.
Yes, what do you want?
your lordship, for timing, your lordship, lordship, they have said that lordship 70% work has been completed. Lordship,
It's not, again, that it says, my lord, actually, the procedure they follow is because in mathematical terms, my lord, it is not exactly possible to pinpoint that this is the percentage of work. So what the contractors normally do, once they do some work covering some amount, so there is a bill. And then, my lord, we do the survey, find out if this is correct or not. So as per that, 1,54 lakh something, that part was over, bill was paid. With deductions, 1,24 lakh something. Then the second bill also they raised of 1 crore something because work is complete, but we have not made them any payment. The third also, my lord, substantively the work is over, and on 15th of March, everything will be over. Whole work. Entire thing within next 10 days. 15th of March. That is the date they have given.
yes, lordship, there are some grounds, lordship, that I would like to place, your lordship. Firstly, lordship,
The direction given by this court.
lordship, what happened, lordship,
NHPC has furnished the status report regarding the status of the work and the payment made in the contractual by way of an additional affidavit. Then a counsel for the petitioner takes some time to
complete his instructions. List on. Lordship, maybe a very short date may be given, Lordship. Short date, list on 19th of March or 18th of March. Yes.
Item number 6 for hearing. My lord, I think this is for impleadment of parties today, my lord.
Yes, Lord.
This is for impleadment of parties.
Impleadment of the Ministry of Tribal Affairs.
My
Amended cost title has not been filed.
My-
Amended cost title has not been filed.
lord,
Amended cost title has not been filed.
No, Lord.
and my lord,
This was-
there is a technical incorrect name has been given, my lord. I will just, my lord, request to peruse this order date 3/8/23. The last order, my lord, 3/8/23, my lord.
Yes.
My lord will
Development welfare of plain.
Department of Tribal Affairs plain. Well, this is the exact department, whereas they have included Ministry of Tribal Affairs. We, in Assam, we do not have any such department, my lord. And always the department has to be, my lord, represented by either principal secretary or commissioner secretary or secretary. Here, nobody is, my lord. If there is consequences, my lord,
Lord,
responsibility will be fixed. Then whom? That is why, my lord, that has to be corrected first. It has to be, my lord, Department of Tribal Affairs plain, represented by either some of the, my lord, senior bureaucrats like principal secretary, commissioner secretary, or secretary, my lord. That go for that.
Yet they have not filed the amended cost title.
no, Lordship, I had filed the impleadment application after the last order passed by your Lordship's predecessor court on 3/8/23, Lordship. Your Lordship has that order. Mr. Dhar submits that third para, Lordship. Mr. Dhar submits that he is desirous of taking note, second para, Lordship. Taking note of the above submission, Mr. Dhar, the Department of Tribal Affairs is impleaded as a party respondent in the writ petition. And then fourth para, Lordship, so and so submits that in view of the nature of the relief sought in the writ petition, it would be essential to implead Union of India as a party respondent in the writ petition. So we have impleaded the Union of India represented by the Ministry of Tribal Affairs.
That included post title has to be, my lord, filed. That post title has to be, my lord, filed to the registry.
It is listed for the first time, Lordship. After this order passed.
But why you have not completed this Department of Tribal Affairs? Because the court is taking note of the above submission, Mr. Dhar, Department of Tribal Affairs plain is impleaded as party respondent in the petition.
Yes,
The
Lord.
court has ordered for impleadment of Department of Tribal Affairs plain. Why you are not impleaded them?
I'll do that, Lordship.
As per order dated 3rd of August 2023, you are required to implead the Department of Tribal Affairs as well as Union of India both.
Very well, Lordship. I'll do that. Second part.
There's notice that pursuant to the direction given by this court on 3/8/2023, IA number so and so is moved on behalf of the petitioners impleading Ministry of Tribal Affairs, impleading Union of India through Ministry of Tribal Affairs as party respondent. However, the Department of Tribal Affairs plain has not been impleaded as party respondent. Full stop. Then concept of the petitioner takes some time to cure the said defect.
Now required to file amendment. This is a redundant application. Amendment already allowed.
The
It is not to the
Union of India
we are of the view that in view of we are of the view that on 3/8/2023, this court has already has already imputed the Department of Tribal Affairs as party respondent and has further directed to implead the Union of India as party respondent in the writ petition. Hence, the petitioner is required to file amended cost title amended court title, including Department of Tribal Affairs claim as party respondent in this petition and a separate application for impleading Union of India as party respondent.
That has been.
We allow these items.
Amended cost title and this they have filed application for Ministry of Tribal Affairs.
Let them know.
In such circumstances, the IA number so and so is allowed. And the Union of, and the Ministry of Tribal Affairs, the Union of India through Ministry of Tribal Affairs is impleaded as party respondent. However, a week's time is granted to the counsel for the petitioner to file amended cost title.
Grateful. Much obliged.
IA is disposed of.
Grateful.
Item number 7.
My lord, I'm sorry, my lord. In this case, my lord, a notification was issued by the, my lord, Ministry. India. A notification was issued, my lord. Whereby, my lord, the Siliguri and Sikkim was brought under the General Office of Kolkata. And cause of action arose at that point of time, my lord, at Siliguri. At that point of time, my lord, Siliguri was within the jurisdiction of, my lord, CAT. And ultimately matter was decided by CAT. Now they have come with a notification that, my lord, jurisdiction is shifted from Guwahati to, my lord, Kolkata. And they made a prayer for shifting of the matter to Kolkata. Into, my lord, my lord, this notification is, cannot have any prospect or retrospective effect.
That's right.
And lordship may be competent to hear the matter.
This court is required to hear the matter only because at that time, there was no such bifurcation.
No, my lord. At that point of time, it was within the jurisdiction of, my lord, Central Administrative Tribunal, CAT, Guwahati bench.
That is in relation to the only CAT,
Yes, my lord.
not in relation to the High Court.
High Court or CAT was under the jurisdiction of Guwahati High Court
At that time,
at that time.
yes.
Therefore, my lord, lordship, if lordship is otherwise, my lord, empowered to take up the matter, then fix it, my lord, I'll prepare the case. Because I was under impression that possibly, my lord, by this notification, matter will be shifted, transferred to Kolkata High Court. At any date, my lord,
After renewal, 18th of April,
Termination and sexual.
right,
Okay, request is made on behalf of the respondent. That seems now the matter related to, where is that notification?
my lord, yes.
That seems why the notification dated 4/5/2017. The Kendriya Vidyalaya Santan reorganized the regions and the national zone. And as per the same, all Kendriya Vidyalayas Santan, Kendriya Vidyalaya Santan of West Bengal and Sikkim now comes under the jurisdiction of Kolkata region. It's great that since all the Kendriya Vidyalaya Santan of West Bengal and Sikkim now comes under the jurisdiction of the Kolkata region. The present case pertaining to Sikkim It is
No,
of second
but Darjeeling, AML or Siliguri.
of Siliguri
Yes.
is required to be heard by the Kolkata High Court. Stop. We are of the view that the notification dated 4/5/2017 not applicable retrospectively, hence the request made on behalf of the respondent of this effect is rejected. This matter for hearing after BU vacation.
Minor.
18th of April.
Obliged,
18th of April.
obliged.
BU vacation.
Minor.
Item number 8.
Wait, Lordship. Lordship, I am making a prayer for adjournment on behalf of resolution number 7, Lordship. Mr. Amjad Ahmed. I submitted my adjournment request also yesterday. He is out of session, so matter may be taken up after some time, Lordship.
But the request of the constable, respondent number
7.
7, that will be adjourned
Obliged.
and we listed after BU vacation.
Item 9.
May I please receive? My lord, as per order dated 16/2/2023, Lordship, the respondent has to file an affidavit placing the materials before the court. So they have filed today only. I have received a copy today.
When they have filed this status report,
Report, my lord, they have yet to be filed, but copy has served to
We
me.
have served it.
Right,
Lordship.
today only.
you are on behalf of
Lordship, I'm on behalf of Council B. Gugoi, Lordship.
Which?
Health Department, Lordship.
Health Department.
Lordship.
Okay. You have filed additional affidavit, counter
Addi-
affidavit.
Yes, Lordship. Additional affidavit,
Okay. Mr. B. Gogoi,
Lordship.
Mr. B. Gogoi, turning consent for the health department has submitted submitted that he is going to file an affidavit today itself. Full stop. Then it consent for the petitioner has submitted that he is already, he is in receipt of the copy of the said affidavit and therefore some time may be granted to complete his instructions. List after come when
My lord, the first week of April, my lord.
PU vacation.
Much obliged, Lordship.
Obliged.
Item number 10 to 12.
This is regarding encroachment of forest land, my lord. Now, the respondents in the forest department were directed to furnish a report over the de-encroachment exercise.
My lord, in this regard, my lords, a comprehensive plan is under preparation, my lords. We need further 6 weeks, my lords. Because, my lords, the area of encroachment has been notified and this pertains to a very large chunk of land in the northern banks, my lords, which are densely populated. So we have to chalk out a plan as regards the eviction also, my lords. My lord, I humbly pray for, my lords, at least 2 weeks, 6 months, 6 weeks time, my lord.
Election is over.
Nikhil, and the concept of the which department you are?
It's forest department.
Forest department has submitted that. A detailed action taken report is required to be filed in this written petition in respect of removal of the encroachment from the forest land.
My lord, that is on, that instruction I place is on, my lord, on record.
Therefore, some time may be granted for the same. Just after 8 weeks.
Item number 11, my lord, item number 11. I have filed a petition for impleadment as a respondent. Can it be allowed, my lord?
impleadment for respondent.
No, 11 no, 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 10 to 11 क्या है? 11 logo है. As regards item 11. Well, this is a slow motor, my lord, PI. Well, in this regard, my lord, on last direction, on the last date, my lord, we are asked to prepare a detailed report, my lord. This report has been prepared and submitted to the Chief Minister's office, my lord. Well, kindly, we'll await what the Chief Minister's instructions.
Why you are asking for the completed as party discussion?
My lord, I have my Pata lens, my lord, upon which some pillars of the forest department has been installed. I filed an application for verification before the revenue authorities. They have jointly verified and they have found that in fact, some of the pillars are installed on my land, my lord.
So they'll remove it.
My lord, for that, the final orders will be if necessary, my
What
lord.
is the need of any order? The court has not passed any order
Lordship.
to remove.
But since the matter is before your lordship,
Otherwise, he can file a writ petition.
Yes,
He can file writ petition for the lordship.
my lord, upon verification,
right.
lordship.
But if this court has not passed any order to place the pillars on the forest land,
No, well, the forest department has placed the pillars.
then the forest department has placed the pillar and if as per the report, they have placed those pillars in your land,
Lordship.
then remove it.
My lord, I on my own will not be able to, my lord, because the revenue authorities have made a joint verification, my lord. I have annexed those reports in my application.
Procedural number 2.
And at the time.
In fact, my lord, many other people have been impleaded.
The applications, so the application filed on behalf of the applicant for impleadment as party respondent in PIL number 27/2013 will be heard, will be considered at the time of hearing of the writ petitions.
Perhaps my lord will fix the date. Elections are approaching, my lord.
After the vacation.
My lord. Oblige, deeply oblige. I'll get it.
Item 13 and 14.
It is your lordship. Lordship, I appear on behalf of the petition, item number 13, your lordship. Lordship, by order dated 12/10/2020, lordship, the government of Mizoram, Arunachal and Nagaland were asked to submit the affidavit, lordship.
Yes.
Lordship, some time may be granted, lordship, to file our affidavit.
This order is of 26/7/2023.
Lordship, in this matter, lordship, already, regarding this boundary, the states, both the states have formed a committee that is also looking into it. And the original suit about this boundary dispute is already pending before the Supreme Court.
The court has simply said that apart from the boundary dispute,
Lordship,
irrespective of the boundary, efforts shall be made on coordination with the secretaries concerned, Assam, Mizoram, Nagaland, and Arunachal to resolve the issue of encroachment irrespective of the boundary dispute.
lordship,
So boundary dispute may be between the two, 3 or 4 states. But so far as regarding forest land, that is for all the states, the forest land is forest land.
lordship, some more time may be given, lordship.
You are appealing on behalf of whom?
State of Arunachal Pradesh, lordship.
And what about the Mizoram, Nagaland?
I also think that.
Why you are not asked for that?
Please.
So in peace mean. And what about Mizoram?
I am from.
Yeah, and what about this?
ये एक साल इंतजार कर रहे थे इनका हो गया तो हम आएंगे.
And who is for Assam?
I'm for Assam.
You have filed this some.
We have filed by us. No, affidavit filed. We have filed.
Non concepts appearing for the Mizoram, Nagaland.
Can I just come in, my lord? But in fact, our PIL is based on an order passed by the Honorable Supreme Court in that, my lord, Godavarman's case. So, my lord, while filing their reply, they should also, my lord, refer to that compliance regarding the Supreme Court direction. And that is most important in this. Because our prayer is that in terms of the, if you also just kindly have a look at the decision once, my lord.
But this court has already taken a conscious of it and on 26/7/2023, That's why only the court has directed effort shall be made in coordination with the secretaries concerned of the four states to resolve the issue of encroachment irrespective of the boundary dispute. So what we are asking, what efforts you have taken for that reason.
Well,
Okay, counsel is appearing for the,
otherwise it's an issue, my lord, which concern each one of us.
that's why we have said irrespective of the boundary land, the forest land is forest land for
Forest.
every state. So every state has to remove the encroachment from that
Mine,
land.
mine.
Boundary dispute is apart from that. The council appearing for the states of Mizoram, Nagaland, and Arunachal Pradesh. Raise some more time to bring on record the efforts carried, the efforts, the steps taken by the said states for removal of the encroachments from the forest land. Stop. This matter after Bihu vacation.
Much obliged.
এটা টেস্ট না হলে একটু মাটি নাকি ডিলে টাইম ডিলে
Item 15.
Please, your lordship. My lord, there is one order of this honorable court. My learned friend was directed to seek instructions.
Minimum pay scale of the appellant in terms of rule 7(1)(a).
7(1)(a).
One of central sales revised pay. Rule.
Yes. He had shared the compilation with me, my lord.
I mean,
They are contradicting it.
He has shared it with me.
No, you are not agreeing to it. This
No,
compilation-
no, my lord. Oh, yes. Office, it is one. It's not in accordance with that rule.
Ready to argue?
Yes.
Finally?
Now, if your lordship will kindly have a look at the rule 7.1, that your lordship will find at page 59 of the appeal brief.
Yes.
Now, 7A1 says the pay in the pay band, pay scale will be determined by multiplying the existing basic pay.
Read the, read from start.
Okay.
Rule 7.
Rule 7 is at page 58.
Yes.
Fixation of initial pay in the revised pay structure. The initial pay of a government servant who elects or is deemed to have elected under sub-rule 3 of Rule 6 to be governed by the revised pay structure on and from first day of January 2006 shall, unless in any case the President by special order otherwise directs, be fixed separately in respect of his substantive pay in the permanent post on which he holds a lien or would have held a lien if it had not been suspended, and in respect of his pay in the officiating post held by him in the following manner, namely, in case of all employees, clause 1, the pay in the pay band pay scale will be determined by multiplying the existing basic pay as on 1/1/2006 by a factor of 1.86 and rounding off the resultant figure to the next multiple of 10. 2. If the minimum of the revised pay band pay scale is more than the amount arrived as per 1 above, the pay shall be fixed at the minimum of the revised pay band pay scale. Now, here, my lord, I take a pause just to take your lordship to page 146 of the appeal brief, where I have indicated the calculation as to how the pay has to be fixed. If your lordship will kindly come at page 146.
One
146 is an additional rejoinder to running marking to. To me, more very sure.
Yes, 146.
Paragraph 5. Paragraph 5. That I say that as on 1/1/1998, my basic pay was fixed at 13,260 in the pay scale of rupees 12,000 to 18,300, as the rate of increment was rupees 420. Accordingly, my basic pay as on 1/1/2006 was 16,200. So far as this basic pay is concerned, my lord, there is no dispute. They also agree that on 1/1/2006, my basic pay was 16,200. Therefore, fixation of my initial pay in the revised pay structure should have been done as per Rule 7 of Central Civil Services 2008. and the pay in the pay band pay scale should have been determined as per Rule 71A1 of the CCS revised pay rules 2008 by multiplying a factor of 1.86 and rounding off the resultant figure to the next multiple of 10. Consequently, my initial pay in the revised pay structure should have been determined as rupees 30,132. Even they even say that it should have been more, but I said only 30,132. As per their calculation, they say that it should have been it should have been around 30,920. The calculation which they have provided to your lordships now, they say that it should have been 30,920, whereas I say that it should have been 30,132. Till this also, my lord, there is no dispute. They are offering me, so to say, few hundreds of rupees more. But the next stage is crucial, where the Rule 7A2 comes into play. And as per Rule 71A2 of the EBID rules, the pay should be fixed at the pay band of 37,400 to 67,400 in the pay band 4 with the grade pay of 8,700. That is the claim of the writ petitioner. Now, this pay scale your lordship will find in the appeal brief itself. Your lordship will find it at page 66. That's page 56, my lord. The scales and the corresponding revised pay scales are indicated, which is part of the pay rules. Now, in the pay rules here, clause 2, your lordship has seen that if the resultant figure that comes out by application of 7A1 is something more than the minimum of basic pay in the revised scale, then it should be placed to the higher pay scale.
No, that you're reading.
I'm just showing your lordship the revised scales at page 66.
66.
66. If your lordship will kindly see 66.
Yes.
In comparison to 59, page 59 and 66 both. Clause 2 says that the resultant figure.
Just a. Is 66 and 59.
59. If your lordship.
In case of employees.
Yes, in case of employees, clause 2, your lordship may kindly see, if the minimum of the revised pay band pay scale is more than the amount arrived as per clause 1. Now, clause 1 says that the basic pay as on 1/1/2006 should be multiplied by a relevant factor of 1.86.
Yes.
And after multiplying 1.86, a figure will come. Now, this figure will have to be placed in an appropriate scale in the revised pay structure. Now, in my case, my lord, the resultant figure comes 30,140. They say 30,920. That is not very crucial. Now, question is on which revised pay scale I should be placed. Now, the rule 2 says
32,100
30,132. They say
your figure is.
Yes, my figure is 30,132. They say it should be 30,920. Whichever way, my lord, it goes.
Yes.
Now, if your lordship will now see rule 2. Rule 2 says
if the minimum of revised pay band pay scale is more than the amount
arrived as per 1.
Above.
Yes, as per 1 above, then the pay shall be fixed at the minimum of the revised pay band pay scale. Now, page 66, your lordship will see entry 25.
Yes.
Entry 25 is a scale against column 5. Column 5 is the revised corresponding pay scale. That is a scale from 15,600 to 39,100.
Yes.
They have placed me on this 15,600 to 39,100. That is, they have placed. But as per rule 2, my lord, I ought to have been placed in 37,000 against the entry 26, which is 37,400 to 67,400. Because it is the minimum of the pay scale or revised pay scale which has to be looked into. The minimum of the pay scale has to be more than the resultant figure.
He was saying by relying upon this page 15 here. One. Payment, payment. Next payment the 31,000. That is the part. If I watch. The argument is started here. If other issues payment, then and they are also included case. It is That's right, because our the name of pay scale, pay scale, these pay scale is still continuing. Then how can you get?
Yes.
Oh, my lord, by application of Rule 7A2, the pay scale, the revised pay scale that they ought to have selected for me is 37,400 to 67,000 with a pay band of 8,700. And that is the reason, my lord, this honorable court permitted me to take this ground by an additional order. See, this ground was not initially urged before the learned single judge. But noticing that this is the area where the, my lord, the case will come, the lordship will kindly see the order of the honorable court on 14/3/2000.
Seen that?
Yes.
The court has allowed you. They
Yes,
have made
yes.
an objection. The court has allowed you.
Yes.
Can I orally you can.
Yes, yes.
Yes. That
So,
is the-
so that is the submission, my lord.
They are, we are considering that very much.
Now, the mistake that they have committed, my lord.
Mr. Datta, according to what is the difference between the expression pay band and pay scale? Are
Well,
these the same thing or they are different meaning?
This has been used interchangeably because the concept of pay scales were previously there prior to pay revision of sixth pay revision. Now, from sixth pay revision, the concepts of pay band scheme, few scales were merged together, having same scale, same pay, but difference was only in respect of the grade pay. Your lordship will get an idea, my lord. If your lordship will kindly see page 66, your lordship will find that couple of pay scales were merged. If your lordship will kindly come to page 66.
No, that we have seen. What the
Yes.
question is, does pay band and pay scale mean the same thing?
Yes, now it is the same thing.
Is there anything to substantiate that? Any literature to substantiate that?
My lord, the rule itself indicates. Rule itself indicates that the scales have been replaced by the pay bands. And the expressions have been used interchangeably. Your lordship will, if your lordship will.
Your argument is that your pay scale by using the formula in A1,
Yes,
1.86% multiplication, etc. So it comes to, according to you, 30,132 rounded off to 140.
yes.
Correct. But you are saying that, so in the revised category, revised pay scale, since the minimum in the revised category is more than what is your pay scale, so you should get a jump straight away to 37,400, which is the minimum of the revised pay scale.
I may just clarify, my lord. This 30,132 is not this pay scale. It is the basic pay.
That's right. These are
It
all
is the
basic pay.
Now, basic pay is one of the component of the pay scale.
Hmm.
Basic pay is the first component of the pay scale, my lord. And on it, my lord, previously the concept of increments were there. So one who would, when one would march forward, my lord.
No, that is all very fine. We are all on the basic pay only.
Yes. Now this basic pay has to be placed in a corresponding pay band.
Mhm.
Now, which will be the corresponding pay band, my lord? That is.
So why are you not claiming 39,100 instead of 37,400? The highest pay scale in your previous band, that you are not claiming.
No. No, 39, no, that is 15,016, that is 15,600 and 39,100. That does not correspond to the previous, the pre-revised pay scale that I was in. My pre-revised pay scale was 12,000 to 18,300. Now, 12,000 to 18,300, your lordship will not find in this rules. So there arose a case of anomaly in this scale. So to resolve this dispute, my lord, the formula was provided. Your lordship will kindly see 15,600 to 39,100 is corresponding to the pre-revised scale of 12,000 to 18,000. That was not my scale. My scale was 12,000 to 18,300.
Yes.
Now, that was my claim. Now, the calculation that they have forwarded, they have said that my fitment has been described as per fitment table number 8. In the second page of the compilation, your lordship will find.
Yes.
Second page, clause 4.6. 4.6, they say pay in the revised pay band is fixed as per fitment table 8 attached to MHRD letter dated so and so. Now, this fitment table 8, your lordship will find at page 47 of this compilation.
Page 45.
47.
47 of?
This compilation, which my learned friend has forwarded.
We'll see the first flag.
Yes, this table 8.
Yes.
Yes. Now, in this table 8, your lordship find that this table 8 is in respect of incumbent deputy registrar, deputy finance officer, deputy controller of examinations with less than 5 years of service in universities and deemed to be universities fully fined by the central government. I am none of the above.
You approach the London single judge with a prayer that you should be treated equal to the deputy registrar.
Yes, that
Learned
they
single judge
denied.
is denied.
Now, after
Now, if they're treating you equivalent to deputy registrar, you are objecting to it.
no, I said that I should be treated as deputy registrar with 5 years of service because I had already completed 5 years of service.
You can't treat yourself as a deputy registrar.
No, that's why. Now, if you say that I can't treat myself as a deputy registrar, they say that I can't treat myself as a deputy registrar. Then I cannot be treated as deputy registrar for all purposes. You can't now for the convenience of this.
How can you claim this parity with the deputy registrar or the other post with 5 years of service of universities?
No, that's why, my lord. Since they have said that I cannot claim parity, I am not claiming parity. I simply want that you apply rule 7A and 7A 1 and 2 and give me my basic pay. Rule 7A 1 and 2 gives you the formula. Now you
are claiming that your pay scale should be fixed in 37,400 to 67,000 plus grade pay 8700.
Yes. Now the reason for claiming this. Now,
He's not a deputy registrar. Question on You are not a deputy registrar.
No,
Let's take it.
no.
You can't claim.
No,
So which is the table which will be applicable for you?
no, Milord, there was a case of anomaly of my skill because I went to the university from the office of the Lokayukta. I was a secretary to the Lokayukta, enjoying the state scale of pay. Now, when I was inducted in the university, Milord,
Got it out.
well, yes, when I was inducted in the university, Milord, then I got a hike in the pay scale. There was a case of pay anomaly, Milord. Then I approached this honorable court. Then this honorable court said that for all practical purposes, my scale would be all along. It will be personal to me, and all along I will retire with the scale of 12,000 to 18,300. So in course of time, Milord, I attained that scale. Now, after I came to that scale, Milord, the pay revision of 2006 came in. So therefore, the question arose in which scale or which band of pay I should be given a fitment. I said that the pay rules say that if a deputy registrar puts up a 5 years of service in this scale, then he will be granted this particular scale. Now, my scale and the deputy registrar scale was exactly same, 12,800, 12,000 to 800, 18,300. So I said that since the deputy registrar also enjoys the same pay scale, and there are two classifications, one is below 5 years and one is above 5 years. If you are providing 5 years, 12,800, 12,000 to 800, 18,300 with 5 years, you are providing great pay of 8,400. So grant me that. They said that.
That way of yours was rejected by the learned single judge.
Yes. That was rejected by them and also by the learned single judge, saying that my post and their posts are different, educational qualification, etc. are different. Therefore, my lord, I said that regardless of that question of drawing parallel between the two posts, the rule also provides it, because the scales are ultimately worked out based on the formula provided in the rule. Now, rule says that if the basic pay is multiplied by 1.86 and the resultant figure is more than the minimum of the pay scale, then it should be fixed in the next higher
So
scale.
your client is retired in 2011.
Yes, yes.
He is drawing his pension.
He is drawing his pension.
So what is the pay scale which is now operating for your client?
That is what they have given, my lord. That is 15,600 to 39,100. Now, this 15,600 to 39,100 corresponds to a scale which I never existed in. That is a scale for a different category of post. Your lordship will find the pre-revised scale in the page 66 itself. It is in respect of 12,000 to 18,000. Whereas my scale was 12,000 to 18,300. So naturally, there I cannot be placed in this scale. Otherwise, it will amount to putting me in a scale to which I never belong. And the
Yes.
So therefore, my lord, the calculation which they have now provided, if that calculation is to be accepted, my lord, then it will amount to putting me in a scale putting me to a scale to which I never belonged. My scale was fixed at the intervention of this honorable court, and it was granted to 12,000 to 18,300. So whatever necessary, your lordship will kindly see the observation of the honorable court in the first round of litigation. This mistake was realized by them because, I mean, since I went from state to that, under the central funded university, so there was a question of disparity in the scale.
Earlier judgment.
Earlier judgment, your lordship will kindly see. 131.
This is 2017.
Yes. And they realized that mistake, they agreed that all along I'll be proceeding on this particular scale. Page 137, your lordship will find that finding. No. I'm sorry, my lord, it is the learned single judge's order. The first order I'm just going to your lordship.
This is the improved judgment.
No, I'm showing the first judgment, lordship. Mistakenly I have cited this page. Asif. Your lordship will kindly have it at page 39. And the operative part is at page 41, paragraph 6. Page 41, paragraph 6. In the result and for the foregoing reasons, the impugned order dated so and so is hereby set aside and quashed, making it, however, clear that the pay scale which the petitioner had been enjoying before the date of passing the impugned order, dated 14/6/2001, would be allowed to be enjoyed by the petitioner, and he would also be entitled to receive further revision of his pay scale as and when the pay scale of rupees 12,000 to 18,300 is revised. But this arrangement would remain confined to the present petitioner alone and would not apply unless the respondent so decide to other persons who may be similarly situated. So this is how I came into the scale of 12,000 to 18,300. Now thereafter they passed an order and gave me the benefit of this scale. But soon thereafter this revision was effected. And therefore I submitted the representation before the authorities saying that the 12,000 to 18,300 has two categories. One is for persons with 5 years of service and one is for persons with less than 5 years of service. Since I have completed more than 5 years of service in this particular scale, so I am entitled to a high. And this is what they had rejected.
Yes, Mr. Chaudhary.
Lordships, so far as the question of putting in 5 years is concerned, Lordship, that is applicable only in the case of Lordship, Deputy Registrar or Deputy Finance Officer of the university. Therefore, the criteria of 5 years, in my humble submission, would not be applicable to him since he is not in that category. Of course, his pay scale has been determined by this honorable court that he will not be given a lesser pay scale. But the criteria of 5 years, Lordship, which is applicable to the deputy registrars and all, that will not be applicable to him, Lordship. Otherwise, Lordship, that is the primary ground on which my friend is harping upon. Otherwise, the calculation which is given by the university is not disputed by him.
No, I have disputed it. I'm not agreeing to it.
Now, Lordship has noted that he has come in as a secretary to the Vice Chancellor. Therefore, from the initial stage, whatever scale that he was getting, Lordship has noted, that was actually not applicable to him. He's getting a higher scale. That was not applicable to him by virtue of giving him a wrong pay scale. Subsequently, coming to the court when it was sought to be reduced, lordship, that has helped him in a way. He stays in that scale.
As per the orders of the.
As per the orders of the court. But so far as the criteria of that 5 years, lordship, that is not.
Then why you are relying on this pay scale, this payment, table A? That is not at all applicable. And what he is saying that irrespective of this, don't treat me as a deputy star, having 5 years service or less than 5 years of service. But as per this rule 7.2, he is entitled to be fixed in the minimum of the pay scale.
Lordship, if I go to page 66, of course, Lordship, that I cannot. Serial number 25 and 26 of page 66.
There was no pay scale of 12,000 to 18,000.
Because if your Lordship will see,
Yes.
25
Yes.
at page 66.
Yes.
Lordship, he would be more than the minimum, Lordship.
He would be more than the minimum?
Yes, Lordship. Here.
He agrees to my submission that I'll be in the.
You are agreeing to it?
That, Lordship, yes. So far as the minimum is concerned, Lordship, under 7.2. That is there, but that will be coupled with the fact, Lordship, that he does not have. That the 5 years criteria will not be applicable to him.
Leave it. 5 years criteria, leave it.
But
if you are agreeing that he is entitled to be fixed in the event, pay scale of 3,000, 37,000, 16,000, 8,770, what remains then?
7.2, Lordship, whatever calculation the university has given, Lordship, but on a plain reading, Lordship, I do feel.
No, it's. Mr. Dev Chaudhary,
Lordship.
there is a problem here.
Lordship.
The earlier round, it was frozen on concession.
Yes.
Given by the university.
Yes.
That his pay scale with 12,000 to 18,000.
That is for his entire.
Correct.
That is for his entire.
Correct. Now, that pre-revised pay scale corresponding to that cannot be what is in entry 25 because there the upper slab is 18,000. And the learned single judges said it is 18,300.
Lordship.
So it has to come to the entry 26, as simple as that. Forget whether it is deputy register, whether it is 5 years, 3 years, 15 years. That order is attained finality and it has to be entry 26 because in entry 25, the maximum slab is 18,000.
It's still the 18,000, Lordship.
Then if you go by 26, what he is asking for, you have to give it. Where is the scope for taking a different view in the matter?
Lordship, that.
No, no.
No, no, that is what, Lordship. I am precisely saying that if it is calculated by.
Do you need time to read the brief? Tell us that.
Lordship.
Do you need some more time to read your brief?
No, I don't need time to read my brief.
Mr. Chaudhary is taking some time to
no,
fix the petitioner in the correct scale.
No, Lordship, the fixation, Lordship, if your Lordship will see from the initial stage, the pay scales would not match.
No, it may be. You have agreed to it and you are paying it in that manner.
Lordship.
Correct your mistake, whatever it may be. Ask the
I can do that. I can ask the university to have a relook into the matter. I can do
that. During the course of arguments, Mr. Chaudhary frankly accepted that the petitioner has wrongly been fixed in the pay scale of 15,600 - 39,100 plus 7600 grade pay. And the pay scale of the petitioner is required to be fixed as per
Rule 7,
Rule 7,
1, capital A, clause 2,
clause 2 of CCS,
revised pay rule 2008.
revised pay rules 2008. And as such, the appellant, petition appellant is entitled to be placed in the pay band oblique pay scale of rupees 37,400-67,000 with grade pay of rupees 8,700 in the pay band 4. Full stop. Mr. Chaudhary, please some time to instruct the respondent university to do the needful.
I don't know.
Time frame for is granted based on
Lordship will give me 2 weeks time.
The 2nd of April,
2nd of
Yes,
April. The 3rd of April.
the 3rd will be Wednesday, miscellaneous day.
So what is the problem?
Coming on hearing board, my lord.
We are not on leave on a miscellaneous.
No,
day.
no,
We
no,
work.
absolutely not, my lord. But only thing is that, my lord, the matter will come in the hearing program. That's why.
4th of April.
Acha, Mr. Dev Chaudhary, just try to find out on this aspect. There was a pay band of 14,000 to 18,300 and a pay band of 12,000 to 18,000. But in the order of the learned single judge in the first round, a pay band which has been picked up was actually not there in your
yes,
table.
yes.
But
18,300.
So, my lord, that the reason is that, my lord, these pay bands are for these pay band on when the learned single judge had decided the issue, my lord, these particular pay bands had not come in. Since he went from the state to the central, my lord, therefore there was a disparity. The scales were not identical. So that's why to bridge the gap, my lord, that particular thing was selected.
that's not reflected in the order. It's passed on a concession by the council,
Yes.
the first round.
Yes. Because the corresponding scale to which he went, my lord, that was high. From the state government, when he went to university, the pay scales were aligned accordingly, my lord. That was the reason. Obliged, my lord.
So Chaudhary, it took so much time in, though you agreed since.
Sir, he has been fair. Last time also, my lord, he agreed. But
Initially, when the writ appeal had come up, these were not grounds taken before the learned single judge.
That you have raised this objection.
No, Lordship, that had consumed more than 1 or
But
maybe
once
2
you are
years.
agreeing to this, his arguments, why you took so much of time?
No,
So they initially, yes, I am agreeing for this.
Lordship, without my clients. Lordship knows.
deeply obliged.
Item 18,
I
sorry.
can see through the table, but maybe
Item 18.
May I please, your lordship, and now.
And you are going to fill the,
Lordship, I have received the instruction, your lordship. As per our instruction, we are not the authority to fill up the regular principal, your lordship.
who is the authority?
Lordship, I have the gazette notification and memorandum of settlement also. The state government is that we have only to forward the gradation list to the state selection board, your lordship.
Who are you?
We are the council, your lordship, and she is council.
It's a government school. It is why government is the authority.
We are.
Who is appearing for the government? Who, Mr. Ardega, you are,
Yes, your lordship. Last occasion, lordship directed me to take instruction because.
and you are going to fill the,
In fact, the respondent was 6 in the present retail matter. He has filed a petition challenging the regulation, and there is an interim order operating in that petition. That is why we could not finalize the,
what interim order is there?
not to give an effect to the regulation. I have received the instruction from the department, and we are contemplating to file an interlocutory application to modify that interim order. Thank you.
Mr. Sigdar, your client has approached the court and got a stay on the gradation list. Then how this regular principal is going to be appointed? How the regular principal is going to be appointed? Stay is already operating, yes.
I don't know about that.
देखिए Ms. R. Deka has submitted that the autonomous council is not the authority who is going to appoint the regular principal, and it is the state government who is supposed to appoint the regular principal in the secondary schools. Full stop. Council appearing for the state has submitted that the process for appointment of the regular principal in the higher secondary school is halted on account of stay order passed in WPC number 3633/2021 filed on behalf of the respondent number 6 and some other similarly situated employees while challenging the gradation list. It is submitted by the council for the state that state is proposing to move into locatory application for vacation oblique modification of the stay order passed by the learned single judge on 11/8/2021 in WPC number 3633/2021 and further process will be carried out as per the order passed by this court in that petition. Full stop. He prays some time to complete his instructions. He prays some time for that. List on 23rd of April. This matter on 23rd of April.
Item 19.
May it please, my lord. I seek your lordship's permission to address to VC matters. This matter comes up, my lords, pursuant to your lordship's order of 9 February 2024, my lords. When your lordships, my lord, took note of the communication of the railways
permitting the opening of the stalls. Essentially, my lords, this assails the judgment of the single judge, my lords, dismissing the writ petition in limine, holding, my lords, that there is no provision for renewal, my lords, of the license under the 2017 policy.
Yes.
Yes, my lords. My lords, the single judge, my lords, dismissed the writ petition in limine, my lords. If your lordships will straight away come to page 34, my lords.
Yes.
I'll just, my lords, the single anomaly, my lords, in the impugned judgment.
Just said in this policy of 2017, there is no provision for renewal, and therefore you are not entitled for renewal. That's
Yes, my
all.
lord. That's all. Now, the single judge, my lord, missed out clause 20.2, which I placed last time, my lord, at page 225. It says clause 20.2, my lord.
Page 225.
Yes, my lords. This is the 2017 policy, my lords. 20.2 at the foot of the page.
Yes.
Tenders that have been finalized and LOA issued prior to the date of notification of this policy shall be allowed to continue as per the policy guidelines prevailing on that date. Your lordships will just note here, my lords. The notice inviting tender in this case was 17/6/2014, and the LOAs were issued, my lords, in January 2017.
That doesn't mean that the policy of 2010, where was the clause for renewal, is applicable on you. It only this protects the LOAs issued prior to the date of notification of the policy. And that doesn't mean that whatever your case is to be guided by the policy of 2010 only. That can't be the interpretation.
The interpretation is this, my lords. My respectful submission is this, my lords. The NIT which was issued on 17/6/2014, my lords, that culminated in a letter of award. Now, my lords, the NIT at page 138, when the notice inviting tender was issued, my lords, had a specific clause, my lords, that the license which will be awarded will be for a 5-year period.
Was in relation to the policy of 2010.
Yes, my lords.
Policy wherein there is a policy of renewal was there.
Yes, my lords.
Now,
just
you can't read this clause in isolation. You please read the further this tenders that have been finalized and the LOA issued prior to the date of notification shall be allowed to continue as per the policy guidelines prevailing at that time.
At that time.
All railways will cancel all
such tenders.
Return the earnest money to the tenders in case where the LOA has not been issued before the issuance of this circular.
Yes,
this clause is only pertaining to those LOAs wherein the LOA has been issued prior to the date of notification of coming into the force of policy of 2017. It doesn't mean that your case will be governed by the policy of 2010 only.
No, my lords. My respectful submission is this, my lords. Under this clause, my lords, the LOA NITs issued and LOA issued prior to the date of notification of this policy shall be continued.
So that be continued up to your whatever the period the license was granted. Not as such that you are entitled for renewal of the license as per the 2010 policy. That can't be, you can't read in this manner, sir.
My respectful submission is this, my lords, that the NIT which were finalized, LOAs issued, the LOA had a clause, my lords.
Yes.
Well, we just have 138, my lords, then the notice inviting tender. the clause in the notice inviting tender in which we participate.
We are aware of your argument. Any
and may I-
law on this point?
My lords, no law, there are 3 other writ petitions pending before the single judge. My lord, there are detailed orders passed by the single judge.
Sir,
Relying on this,
Whether those
writ petitions are pending.
whether those interim orders are binding on this division bench, sir?
No, definitely not, my lord. All I am saying is, my lords, the single judge, my lord, when all these orders were placed, single judge took another view. So that's why I am before your lordships, my lord. Otherwise, my lords, insofar as the right, whether, my lord, this right will inure, my lords, to those whose NITs were issued prior to the circular of 2017, are pending before the single judge. The three matters, I may just give your lordship the writ petition numbers. Detailed interim orders passed, my lords. I am not saying that they are binding, my lords. All I am saying is the matter is otherwise, my lord, at large before the single judge.
Chaudhary,
Yes, my lord.
this writ appeal number 47/2023 and 54/2023.
Flush.
Passed with the division bench.
Yes.
Where are the orders?
Worship, I have got.
In fact, if your lordships have the order of 27th April 2023, my lords, in this matter,
If I may pass.
Where is the order in retable 87 of 2023? Order dated 10/3/2023, retable 87 of 2023.
So, yes,
in fact, my lord, if your lordships have the order of 27th April 2023, my lord, in these proceedings,
27th of?
April 2023, my lord, when status quo was granted
Okay.
by the then Chief Justice.
What do you mean now? You mean to say the status quo, once the court has granted status quo, therefore?
No. Just have, my lord, the statement of my learned friend, Mr. R.K. Dev Chaudhary, learned Deputy SGI, submits that as per instructions received by him, the case is not covered by the order passed in writ appeal number 54 of 2023. And he needs time to file affidavit on behalf of the.
By the order, which is, and what is this order 54/2023?
This is what is relied upon by the single judge at page 34.
Page
34 of the impugned order.
That was a case where the lease had expired, and on expiry of the lease, it was not renewed, and they had approached the court.
But the railway said, my lord, the documents are not valid. So based on that, my lord, they moved the court.
You have on your argument, please, you address on your argument that as per this clause 20.2.
Yes, my lord.
You have a right of renewal of a license.
I'm
Yes, any
grateful.
law in support of it.
Yes.
Any law in support of it.
My lord, the judgment, my lord, of the Supreme Court in SCR caterers, my lord, was in the context of railway vendors at page 71, my lord, 2016 3S.
That is in relation to policy of 2010.
2010.
Then.
Yes, ma'am. 2010 policy, court said ultimately livelihood, my lords, Article 21 code said these are petty vendors.
Sir,
Allow them to.
that doesn't mean if there is 2010 policy is now repealed or not in existence and
Yes, ma'am.
2017 policy is in existence. The Supreme Court has passed that order, taking into consideration
The
that in
2010
the 2000 policy, there is a renewal.
right of it.
There was a renewal clause, but here no such renewal clause is there. So far as our understanding is concerned, 20.2 protects only the existing license, but only up to their term and not beyond that.
My respectful submission, just have page 138, the notice inviting tender first, which was issued, just 138,
Yes,
the tenure of the license. When we place the bid
yes,
at the foot of the page, tenure of the license. The tenure of this license shall be initially for a period of 5 years from the date of commencement of the license, with a provision of further renewal for a period of 3 years.
you are referring to policy of 2010.
No, this is the notice inviting tender on the basis of which the contract has been awarded.
Fine.
Well, the 2010 policy, that particular clause, your lordships will find at.
Tender was awarded to you when?
It was awarded to me on 9th January 2017.
Okay.
For 2 stalls and for 1 stall, 17 January 2017.
Fine.
The catering policy came into force, 2017 policy came into force with effect from 27 February 2017.
After that.
After that.
After that. Yes.
Yes, now, that page 138, your lordships have seen,
Yes.
The tenure of license shall be initially for a period of 5 years from the date of commencement of the license, with a provision of further renewal for a period of 3 years on satisfactory performance and payment of all dues and areas, and withdrawal of court cases if any. Renewal will not be a matter of right. The terms and conditions of renewal will be governed by the catering policy 2010 or any other instructions issued.
That's all.
Yes, Now, based on this, we were issued the letter of awards. Those letter of awards, your lordships will.
Conditions, so the terms and conditions for
Yes,
renewal will be governed by the catering policy and or any other instructions issued from time to time. So from time to time, any other instructions issued from time to time. Now, the renewal is not provided in the year 2017 policy, and certainly you are supposed to govern by the 2017 policy. That's why only they make it very clear. Terms and condition of renewal will be governed by the 2010 policy or any other new policy.
Yes, in the 2017 policy, there is no right of renewal. That clause, your lordships will find clause 11.
Yes.
At 221, if a lordship says, we are minor units, so 11.2 will govern, page 221. Tenure of food plaza, the lordship says page 221.
Yes.
The tenure will be governed by 11.2. Tenure of food plaza shall be for a period of 9 years. Tenure of all other catering, mobile, major units and minor units will be period of 5 years only. There will be no further extension renewal except for units specifically referred to in clause 3.8.1. So it says no further renewal. 3.8.1 concerns base kitchen. We are not governed by that.
Yes.
And then alongside this, I will lay stress on clause 20.2, which I have placed at 225.
Yes.
So, tenders that have been finalized and LOA issued prior to the date of notification of this policy shall be allowed to continue as per policy guidelines prevailing at that time. So, I pause here, So, policy guidelines prevailing at that time, was the 2010 policy when the LOA was issued to me. I participated in an NIT of 2014. So, my lord, my respectful submission is this clause 20.2 saves, my lords, tenders awarded prior to the date of the policy coming into force. If that be so, my lords, it will be governed by the policy prevailing at that time. My respectful submission is, my lords, that policy had a right of renewal of 3 years.
Yes.
And the second sentence, my lord, which your lordships referred to, my lord, zonal railways will cancel all such tenders and return the earnest money where LOA has not been issued. So, if, my lords, there was any tender, my lords, which was yet to be finalized, zonal railways was directed to cancel it and return the earnest money. But tenders which have been finalized with the issuance of the letter of award, my lords,
Yes.
was saved under clause 20.2, permitting, my lords, an extension under the 2010 policy.
Yes.
Now, my lords, please have page 70, my lords, the order which I impugned before the single judge.
Yes.
Page 70, my lords.
Yes.
This is to inform you that the license period of catering stalls allotted to you at Guwahati and Kamakya, including the 5-year license period as well as 10 months extended period granted on account of COVID, have already expired as per details given below. I am 1, 2, 3. So my expiry otherwise would be 1st February 2023 or 3rd January 2023, my lords, for the other stalls.
Fine. That period is over now.
So my submission, my lords, is, my lords, subject to, of course, meeting your lordships approval, is that, my lords, I am entitled, my lords, under the policy as then prevailed, my lord, the extent policy then prevailing for a 3-year renewal.
Fine.
Which I had invoked, my lords. And, my lords, the other 3, my lords, 4, 5, 6, of the same impugned order, my lords, their writ petition is pending before the single judge, where there is an interim order, my lords. In fact, there are 3 writ petitions, my lords. I must just give your lordships the numbers of the writ petition, which are pending before the single judge. One is, my lords, writ petition 1719 of 2023.
Fine. So,
Then, my lords,
what to do with the pending petitions? We'll call those petitions here before the division and decide it.
very well, my lord. Either your lordships can call it,
Why, Mr.
or otherwise, my lord, there are details.
Your petition is already dismissed and you want that other petitions may also be.
No, I'm not saying that. I'm not saying that, my lord. I'm not definitely not saying that, my lord. Those petitions are pending, my lord. All I'm saying is,
you are the counsel in those petitions.
no, my lord, I'm not.
Then how can you even
My
ask
lord,
for?
my lord, what I'm saying is this, my lord. What I'm saying is, my lord, I didn't have my day in court before the single judge. Single judge dismissed it in limine, my lord.
Yeah, is it not permissible?
But it's permissible, my lord. But I'm saying, my lord, is when 3 other writ petitions are pending, my lord, there are other honorable judges.
The other writ petitions are pending. That would be decided. Those petitions will be decided in due course whenever their turn comes.
Well, just my humble submission, my lord, is these are otherwise, my lords, petty contractors, my lord, they run the stalls in the railways, my lords, in the railway stations.
Apply for this in the new policy.
Whenever it is, but all I was saying, my lord, I had a right of renewal, which I'm invoking, my lord, subject to meeting your lordship's approval, my lord. Whether that right, my lord, inures to my benefit after the 2017 policy.
Fine. Anything else?
That's all.
Yes.
Lordship, admittedly, the work that was awarded to my friend's client, that was from 2017. It was for a period of 5 years, Lordship, and contract says so. He has signed the contract. Thereafter, Lordship, since it was under the 2010 policy, Lordship, yes, he got the 5 years period, although this new policy had come into effect from 2017. Since the tender process was already before, he was given the contract for 5 years.
New policy came into force in which date exactly?
2017, Lordship,
27 February 2017.
2017. And once the tenure is over, Lordship, he has to go by the new policy. And in the new policy, Lordship, tenders are called. He can participate there. I have given an instance in my affidavit, Lordship. What has happened is when we have called for tender, we get more revenue, Lordship. We are getting more revenue than simple renewal, Lordship. He can apply there, Lordship. So once the period is over, Lordship, now he will be governed by the new policy of 2017. And there is no clause for any renewal.
Yes.
That's all.
Is something else, Mr.?
That's all, my lord. I made my service.
Argument, sir. Order is up.
Grateful, my lords, for patient hearing.
Item 20.
May I please, the lordships? My lord, during the year 1960-62, some plots of land of various persons were acquired by the government for the construction of national highway, my lord. During that time, my lord, people were not so aware about their rights. Right? The government also did not pay the due compensation to the parties in appropriate time, my lord. Of late, only during the year 2000, the process started for payment of compensations, my lord. Now the petitioners, who are the original writ petitioners, they filed representation and that they are actually, first time they were waiting that they would get their compensation within a very short time. And they visited offices, etc. And they were told shortly you will get. In that manner, my lord, things were going on.
There is any assurance on the part of the authorities, or why you are so hopeful that?
My lord, since 2014, my lord, there is communication from the government, my lord.
Yes.
And National Highway Authority. Since the 2014, my lord, in 2014 also there is letter that we should be paid. Lordship, kindly, this is very important matter. Learned single judge has dismissed the writ petition only on the ground of delay.
50 years delay.
No, my lord, I will satisfy you.
2016, the land was acquired.
My lord,
For the first time you raised your voice in 2010 and thereafter approached the court in 2018.
My lord, let me satisfy your lordship, my lord. Thing is this, my lord, lordship would kindly go visit 1960. At that time, what was the condition of the people? They were not so aware about their rights, my lord. And 1884, my lord.
That can't be a ground.
Just other day, my lord, the other day, honorable.
In any case, you can take this ground case up. He was not
My
aware
lord.
about this law and all, and not so vigilant.
Just,
Therefore,
my
he
lord,
can
in
come to the court
January.
At any point of time.
My lord, just in January 2024, the Honorable Bombay High Court has passed, or division bench has passed order on the basis of the Land Acquisition Act 1884, my lord. After 40 years, my lord. That judgment, your lordship may, that is WBC 1430/2022, para 14, 40 years delay is there, order dated 5/1/2024. That was at 1884, after.
Supply is the copy.
My lord, my lord, we have many other judgments of the Honorable Supreme Court. I've
Tukaram
already,
is the main judgment.
my lord, I have given all the citations. And lordship, let me.
Tukaram is the main judgment.
My lord. Now, lordship would say one thing, my lord. Since the year 2014, there is communication. My lord, may I kindly see 187 of the appeal, page 187. This is the notification 28/3/2014. In pursuance of government letter number so-and-so dated so-and-so, the district level land valuation committee has carefully examined the matter relating to enhancement of value of land in all circle offices of Borpeta, both urban and rural areas in the Borpeta district. We are in Borpeta district. In view of the escalation of the price of land and changing pattern of use, and it has decided to enhance the value as shown in Annexure A. Now, Lordship will kindly see, these are page 188, these are our land. These are our land, page 188. Borpara Road, town roadside within 200 meters of main road. This is our land.
This is your land. How this is your land?
This is our land, well, there is the inquiry report of the circle officer.
What inquiry report was
Yes,
there?
my lord, I am showing. It Lordship may kindly see page 184, my lord.
184.
Yes.
Yes.
Here, Lordship would see this is circle officer inquiry report on public allegations regarding non-payment of compensation for land acquired for construction of 31 National Highway under Borpeta Road, town within Borpeta district, my lord. So, Lordship would see here the name of Pata number 504, dag number 1488, Hemanta Kumar Mandal. My lord, he is one of the petitioner number 1 in the writ petition, my lord. Then Lordship would see Pata number 182, dag number 1517, this is Ananta Mandal, he is one of the writ petitioners. Then Lordship would kindly see Pata number 380, dag number 1874, is here Shyam Sundar Khatriya. He is also one of the petitioners. Then Lordship would kindly say,
Okay, this is what the this report, but why your name is not reflected in the revenue record?
our names are, my lord, that is the, my lord, with respect.
Your name was not figured in the is not reflected in the revenue record.
It's reflected, my
And
lord.
in the year 1964 or something, your name was removed from the revenue record, and against which you have not taken any steps.
No, my lord, that is absolutely, my lord, not
1969, and you have
No,
not
my lord,
taken any
that,
steps for that.
my lord, let me satisfy your lordship. When the land was acquired by the government, it has become khas land. But before that, it was Pata land.
No.
No, that is, then why, my lord, our names are there? This circle officer, he is the local owner of the land matters.
Yes.
Circle officer. Circle officer has written dag number so and so in the name.
Okay, we agree with it, that the land was in your name.
Yes.
It was recorded in the revenue record after construction of the highway.
Yes.
As a government land.
My lord.
But why you have approached this court after 50 years seeking compensation, you just satisfy on us, on this?
Then lordship may kindly see some citations, my lord.
Yes.
Lordship may kindly see. I have given the citation also. Kindly see 2020 to SCC.
Yes.
Two 2022 SCC 569, para 12 to 14. Para 12 to lordship may kindly see, page 572. The right to property is to be a fundamental right by the Constitution 44th Amendment Act 1978. However, it continued to be a human right in a welfare state, and the constitutional right under Article 300A of the Constitution. Article 300A provides that no person shall be deprived of his property save by authority of law. The state cannot dispossess a citizen of his property except in accordance with the procedure established by law. The obligation to pay compensation, though not expressly included in Article 300A, can be inferred in that article. Then 12.3, my lord, forcibly disposed. It will be, if the compensation is not paid, then it will be a forcible disposition of a citizen, my lord. Now, lordship may kindly see 12.6, my lord, 12.6, page 573. In Jilubhai Nanabhai Kachar versus State of Gujarat, this court held as follows. In other words, Article 300A only limits the powers of the state that no person shall be deprived of his property save by authority of law. There has to be no deprivation without any sanction of law. Deprivation by any other mode is not acquisition or taking possession under Article 300A. In other words, if there is no law, there is no deprivation. Then para 12.8, my lord. The contention of the state that the appellant or her predecessor had orally consented to the acquisition is completely baseless. We find complete lack of authority and legal sanction in compulsorily divesting the appellant of her property by state. Then lordship would kindly say 12.12. The contention advanced by the state of delay and laches of the appellant is in moving the court is also liable to be rejected. Delay and laches cannot be raised in a case of a continuing cause of action, or if the circumstances shock the judicial conscience of the court. Condonation of delay.
Yes.
Condonation of delay is a matter of judicial discretion, which must be exercised judiciously and reasonably in the facts and circumstances of the case. It will depend upon the breach of fundamental rights and the remedy claimed, and when and how the delay arose. There is no period of limitation prescribed for the courts to exercise their constitutional jurisdiction to do substantial justice. Then lordship kindly see 12.14. In Tukaram Kana Joshi versus MIDC, this court, while dealing with a similar fact situation, held as follows. There are authorities which state that delay and laches extinguish the right to put forth a claim. Most of these authorities pertain to service, jurisprudence, grant of compensation for a wrong done to them decades ago, recovery of statutory dues, claim for educational facilities, and other categories of similar cases, etc. Though it is true that there are a few authorities that lay down that delay and laches debar a citizen from seeking remedy, even if his fundamental right has been violated under Article 32 or 226 of the Constitution, the case at hand deals with a different scenario altogether. The functionaries of the state took over possession of the land belonging to the appellants without any sanction of law. The appellants had asked repeatedly for grant of the benefit of compensation. The state must either comply with the procedure laid down for acquisition or requisition or any other permissible statutory mode. In the present case, the para 13, my lord. My lord, para 13 may be seen.
Yes.
In the present case, the appellant, being an illiterate person who is a widow coming from a rural area, has been deprived of her private property by the state without resorting to the procedure prescribed by law. Then lordship would say, 14, my lord. The state has submitted that in 2008 it had initiated acquisition proceedings in the case of an adjoining landowner by Sri Anak Singh pursuant to a discretion given by High Court in Anak Singh versus of Haryana, instead of Himachal Pradesh, by the High Court, and not in case of other law landowners whose lands were compulsorily taken over for same purpose, and at the same time, as a consequence, the present landowner has been driven to move the court in their individual cases for redressal. So, my lord, here lordship would say, the Honorable Supreme Court has clearly said that delay and laches cannot extinguish the right to a property. Otherwise, my lord, that would be forcible possession, my lord. And
Mr. Mahmood, please read the last sentence of para 13.
yes, we We exercise our extraordinary jurisdiction under Article 136 and 142 of the Constitution and direct the state to pay compensation to the appellant.
142,
Yes, and 136.
36, we are not
No, but
exercising jurisdiction on Article 1.
I know that is the
36 and
power
we
of the
don't have
Supreme
any
Court.
power
Lordship, let me satisfy.
of
my lord.
142.
My lord, I am now on a street, my lord. My entire property, kindly let me give some time. I will definitely, I will satisfy your lordship. Because
We are giving you, we are hitting you, so we are not supposed to make any query.
no,
So
definitely.
it's okay then.
But
Okay, please
but I will
argue it.
satisfy. No, my lord, I am not on
You
that.
argue it.
My lord, I am not on that. I only say,
Okay, yes.
I am satisfying your lordships. On every point, I will satisfy. Kindly, now 136, 142, my lord. There are also judgments, lordships, that under Article 226, even the High Court has some more power than Supreme Court under Article 226. There is such type of judgment. 226, there is some matters cover more 226, my lord. The Article 226 has a limitation, my lord. That type of judgment I do have. Now, lordship, kindly say on the same point, my lord. I'm saying. I am giving a latest judgment, Bombay High Court judgment I have sent my junior. Then lordship may kindly say 2022, 7 SCC 563 para 18.4 to 21.35. 18.4. 563 18.4, madam. Para 18.4. My lord, 18.4, page my lord 574. That the High Court has considered the settled legal principle relating to computation of fair market value. It is submitted that the landowner's original claimants had relied upon the sale exemplars of small plots in village Lohara. In village Lohara, where an industrial estate exists and the orders passed by the reference court in the present case. It is urged that a meticulous exercise has been made by the High Court and considering the same exemplar produced as Exhibit 41, which was with respect to very village of Bayar, has discarded the other evidence and has rightly determined the compensation by relying upon the sale exemplar produced at Exhibit 41, my lord. Then that is regarding the value, the valuation of the land. Now, my lord, may kindly see para 21, my lord. The para 21. The learned counsel appearing on behalf of the acquiring body as well as the state have also relied upon the decision of this court on ONGC Limited versus so-and-so versus so-and-so on the cumulative increase which we would vary from 10 to 15% per year in the market value. Then lordship would say para 35, my lord. Para 35. Here is a chart given, my lord. Here is a chart is given. So that chart has been given by the Honorable Supreme Court, how the market value has to be calculated. Then lordship would kindly say 2022 live law, let's say.
Will come late, so sorry. ये दुनिया में करने invest over in payment.
8 to 7. This one.
Para 5 and
5 and 4. There are 5 and 4 lordship values. Para 5 may be seen, my lord.
Yes.
In obedience of this order, the MTDC deposited 50% amount of compensation in this court. Thereafter, original claimants filed civil appeal number so and so for withdrawal of the said speed person. 8 to 5, 8 to 5. Lordship, paragraph 5, it was wrongly written. While questioning the orders so passed by the High Court, learned counsel for the appellants has referred to various orders passed by this court from time to time in similar matters involving akin issues, including the aforesaid relied upon order dated 10/9/2013 in civil appeal number so and so. The learned counsel has contended that appellants who lost their land way back in the year 2001 could ultimately receive the amount of compensation only in terms of the orders passed by this court on 29/1/2018, and they cannot be deprived of the same on the hyper-technical submissions sought to be made by the applicant MTDC, which had wrongly been accepted by the High Court. And then Lordship.
How this case is relevant, sir?
Well,
Compensation, still the compensation is still to be calculated, determined. You are here that grant as compensation, what is the, how this case is at all relevant for that purpose, sir?
My lord, may I kindly see para 14, my lord? Para 14.
Yeah, what para 14?
Para 14. Before closing this matter, we are compelled to observe that orders passed by the courts and particularly by this court are required to be understood on their feet and substance while avoiding an approach of technicalities. Moreover, this is the word technicalities. Moreover, when the matter relates to the payment of amount of compensation to the landlords, if at all two views are.
It is to be determined whether you are the real owners or not. You have simply come to the court case, sir, land of my forefather or my grandfather was acquired way back in the year 1962. How many heirs are there? How many dependents are there? These questions have to be taken up later on.
They are on record, man. They are already on record, man. Well, one thing, if the lordship is on doubt that land may not belong to us, then lordship may call for a report from circle officer or DC.
For what?
Our submission is the inquiry officer, the circle officer inquired the matter and found our names are recorded in the lands which were acquired. So that is on record, my lord. And not only this, my lord, a large number of communications, my lord. Let me show you some communications in this regard, my lord. My lord may kindly see what are the communications. Those communications, lordship would see from page 158. Our representation was page 152. So here, Hemant Kumar Mandal is there, my lord. A person who is page 152, my lord. Hemant Kumar Mandal, he was the president. In that capacity, he filed the application, my lord. Then lordship will kindly see, this is the endorsement of the deputy commissioner, page 153. It is in vernacular, but that portion is written in English. Circle officer Bornagar, please verify the records, inquire the details, check land records, and furnish your replies. So thereafter, circle officer submitted detailed report that yes, these persons are the owners. Then, my lord, thereafter also there was also other communication, that is 156. Lordship will kindly see. Bottom, please verify and report as per eligibility. So 156 bottom. Then, my lord, communication is starts from the department. 157 lordship kindly see. This is the chief engineer, my lord. Chief engineer starts inquiry, and thereafter various communications. Lordship would see page 157B. This is also another letter of executive engineer. Earlier was a chief engineer. This is executive engineer. Then lordship would see page 158. This is from circle officer Bornagar Revenue Circle, 158. Here, our name is clearly mentioned, my lord. With reference to the subject cited, I beg to state that Sri Hemanta Kumar Mandal, son of late Ganesh Mandal, has filed an application on 21/5/69. So, Lordship, here Lordship would kindly see Hemanta 21/5/69, my lord. So it is not correct that only 2010, but copy is not kept. That is the problem, my lord. Because of, but it is reflected in the letter of the circle officer. He is a government officer, my lord. And National Highway Authority knows well, they are also ready to pay. And there are, I am showing my letter on, my lord. So our application, first application was 21/5/69, but copy was not kept, my lord. So that Lordship will kindly see, and this is the letter of the circle officer, the grassroots level land officer, my lord. Then Lordship would kindly see page 160. This is Chief Engineer, Piruli, Assam. So Lordship would here see, here case number is also given, letter number is also given. It is dated 27/2011, my lord. Then Lordship would see page 161, my lord. This is government letter, undersigned to the government of Assam regarding acquisition of land on National Highway 31 during 1962, non-payment on compensation for acquisition of land in Borpata Road town. This is our Borpata Road town is ours, my lord, where there our land is situated. Then Lordship would kindly say page 162, my lord. The same thing, my lord. This is Chief Engineer, Assam. Chief Engineer, Assam, my lord. That is 31st October 2011, my lord. Then Lordship would see page 163, my lord. This is the additional deputy commissioner, my lord. Here Lordship would see, let me read the relevant portion, my lord, page 163. With reference to the subject cited above, I have the honor to enclose here with a copy of the application submitted by Sri Hemanta Kumar Mandal, son of late Ganesh Mandal and others of Kolohabanga village, Kostabir Borpata Road, and verification report submitted by the Circle Officer, Bornagar Revenue Circle, Sorvok, along with its enclosure. As per Circle Officer report, the said land measuring 11 biga 4 gatha 2 lesa was acquired by the SDC number so-and-so for construction of National Highway 31. In this regard, I am to request you kindly to take necessary steps on the matter regarding payment of compensation of land, my lord. But our land is not 11 biga, my lord. Our land is 7 biga. There are some other lands also. Our land is almost 8 biga, 7 biga, 4 gatha some. So, my lord, here clearly regarding payment of compensation of land and Jirat in.
Mr. It shows the national highway was constructed on a stretch of land involving land of other persons also.
Yeah, they have got, my lord. They have got compensation in the.
Well,
yes, I am showing, my lord. I am showing, my lord.
Well, they got compensation.
My lord, can you see page 198, my lord?
Acquisition proceedings,
My lord,
para,
page 198 and 201 of the contemporary time.
$198, yes.
198, my lord. Can you see? To Muhammad Manullah Sheikh, village Sainuddin, village Goraimari. Yeah. Son of Sainuddin, village Goraimari, regarding compensation of land acquired for construction of National Highway. It was paid on 4/9/2008, my lord.
Which national highway?
Yes, the same National Highway.
How can, where it is mentioned?
31, my lord. Everywhere
Where
31.
it is mentioned national highway number 31?
Yes. Yes, my lord.
Yes. Yes.
This is Bangaigaon, that
Let me say.
is also separate.
Well, there is only one highway, that is, that is read done. Regarding compensation of land acquired for construction of National Highway. So National Highway, it was paid in to Manullah Sheikh on 4/9/2008, and National Highway Authority the same authority, my National Highway Authority. And my lord, in that area, my lord, there is only one national highway. No other, and in southern bank, there is another highway, but 31 is that very from Srirampur up to Guwahati, which national highway, it is 31, my lord. It is judicial notice, it can be inferred. How can I say lie before your honorable court, my lord? Well, Learned Friend knows very well. Now, my lord, we are most interesting, important thing, my lord, I am now showing your lordship, that National Highway Authority, who are the main authority to pay, they are ready to pay. They are ready to pay. I am showing their letter.
Then why won't you ask them to give?
But my lord,
They are ready to pay, you are ready to receive.
my lord, they are ready to pay.
Settle it out.
It appears from their letter, but thing is this, my lord, authorized officer is the Chief Secretary, Government of Assam. Additional Chief Secretary, Revenue, Government of Assam.
So there is nothing, nothing is going out of the packet of the national highway, pocket of the national highway. They say, yes, you
My lord,
take the
one thing-
compensation and state will give the compensation.
Even, my lord, the Deputy Commissioner Borpeta, who is the district level officer of payment, he wrote a letter to Chief Secretary, pay them, kindly pay them. His letter is also here, my lord. But surprisingly,
There is no satisfactory explanation. Why they are
There is all possibility
my lord,
that the authorities have approached your grandfather or whatever it may be, that we are going to construct a road and he happily offered his land. Okay, construct it. The national highway is going to be constructed from my land. Certainly, the price of the land will be high. So you may construct it
No,
without,
at that
you
time,
might have agreed on that time.
the people were so simple, my lord. They were not so critical, man.
There is a possibility.
Because
And they have constructed the road as per the assurance
No,
given by you.
we are pursuing the authority since 69, my lord.
Then your, the land order of this grand, parent, the granddaughters or sister,
No, but
sons,
that is
they
not,
became wiser now, okay, then we'll ask for from the
that is
government, the
not at all our
compensation.
motto,
The rates
because
are so high.
officers are always saying, circle officer, page 86, he is saying, 186, that they should be paid compensation. Then, lordship, I am showing one thing, my lord, how we issued a legal notice. When all communications in our favor, but not paid, then we issued a legal notice on
First communication with the government for payment. The first communication with the authorities concerned for making of payment.
that it appears from 69, my lord. And
First
my lord,
communication. The petitioners have approached the government for the first time for payment of compensation in which year?
69.
69. Is there any document? Can please?
No, that is not there, but it is reflected in the letter of the circle officer, my lord.
What do you need?
My lord,
You
that-
just show us. And after 69, when you approach the authorities concerned again,
No, continuously we are following and there is
which is
communication.
where is the continuous, the
No.
proof that you are approaching the
My
court
lord.
continuously?
So in writing, we do not see, but government
you
communications
go
are there, my
with,
lord. Government communications are there, my lord, that they should be paid, my lord. And
So your principal argument is that without going into the technicalities or the limitation question, please, Mr. Mahmood, your main argument is without going into the technicalities or on the question of laches delay, there is ample proof that your land was acquired by the national highway for the purpose of construction of national highway, and therefore suitable compensation be paid to you.
Yes.
This is what their main contention. And the learned single judge has simply, on the basis of delay and laches, has dismissed the writ petition without going into the authoritative pronouncement by the Honorable Supreme Court.
Yes.
This is what your argument is.
That is also there, but technical point cannot defeat the substantial cause of
That's
justice.
why only I already in my opening remark, I said without going into the technicalities.
But I have given the Bombay High Court judgment recently, that was passed in January. That is also division bench order, my lord. After 40 years, case was filed and relief was granted, my lord.
Fine.
Para 15, Lordship may kindly see, para 15. There are 15, 26. There are 15, my lord, and 26, 29, 67. There are 15, Roman 1 is, I think, more valuable. The writ petition is hopelessly delayed and vitiated by delays and HS. According to the MSEDCL, the writ petition is filed nearly 40 years after taking over possession of the subject land on 19th April 1884. That is nearly 28 years, nearly 28 after the construction of the substation. That has been discussed, very beautifully discussed all the points of Land Acquisition Act.
Mr. Sharma?
My lord.
What about the records of this? There's a circle officer's report, which is obviously based on record.
Lordship may kindly see the affidavit in opposition filed by the additional deputy commissioner in this case.
Yes. Which
My lord.
page?
Page 76. Paragraph, my lord. Page 82, last paragraph, my lord.
Page?
82. Further, as reported by the last paragraph, my lord.
Yes.
Reported by the circle officer Barnagar, the original copy of the letter addressed to the chief engineer PW Shanbari Guwahati dated 8/8/2011 from the circle officer Barnagar Revenue Circle Sharpo could not be traced out in the office of the circle officer Barnagar Revenue Circle Sharpo, and hence authenticity of this document could not be established as of now. Then your lord, paragraph 6 at the next page, my lord, page 83. That with regard to the averment made in so and so, the deponent reiterates that averments made in paragraph 3 and 4 herein above. Further, it is submitted that as no record of land acquisition case pertaining to NS 31 in the year 1962 is found in the office of the Deputy Commissioner Borpeta, and in the absence of the same, it has become difficult to ascertain the claim of the petitioner, as more than 50 years has already been elapsed since the state acquisition. Moreover, although the petitioner has annexed some interdepartmental communication of the respondents to establish their claim, but there is no explanation on a belated filing of the instant writ petition in the year 2015, except execution of the power of attorney dated 19/3/2015. That too without any specific land acquisition case details showing their entitlement for compensation. Hence, the prayer made in this writ petition cannot be heard. The stand of the application. And page 100 is the impugn order of the writ petition. As per my lord, impugn order paragraph, third paragraph, my lord, page 100. As per manual of
Just
the,
a minute.
my lord.
Written in the name of the thing is. Even for the community for the this. Is of the because. Instead coming. It's a Yes, yes. Yeah, apart from other things, it's not making it impossible for any authority to verify it. There can be a mathematics. When if mathematics could be there, consider the plain expert become could be the record side. Or the fact nobody can be. 62 में the land became certain. 62 तो पहले 60 ये सत्य लग रहा है ये डॉक्टर लगता है परिचय किसी लड़के में आते हैं ये भी हो सकता है क्या देखिए ये बड़ी डीप है कहीं वैल्यू भी नहीं होगी है ये अगर इनको होता तो वो बेटर रहता अभी ये जो इनके सारे आज के लाए जिंदगी लगाओ देखते हैं क्या होता है convincing to
Yes. My lord, lordship may kindly see the impugn order in the writ petition, my lord, page 100, my lord.
100
My lord.
yes
Second paragraph, my lord, Deputy Commissioner Berpeta has informed, it has reported that the correction of the land record for so of land in village Borpeta town, Road Moza so acquired in the year 1962 for construction of National Highway 31 has been done during the year 1969. DC has also informed that no records regarding payment of compensation to the purchaser of the land in question is available in the office of the Deputy Commissioner Borpeta, nor the records could be traced out in the office of the Chief Engineer, PWD, MS Works, Assam, Guwahati. The petitioner have also not been able to produce any documents to prove their claim. Then, my lord, as per manual of the land acquisition, the land records are corrected after all formalities, including taking over possession. Payment of compensation are completed with regard to the land acquired. Therefore, in the instant case, as the land record were corrected way back in the 1969, it can be safely inferred that compensation were paid.
My lord, I have a
And
short
since
reply.
1969, my lord, they have not made any communication, my lord. Although, my lord, land was, my lord,
So, Mr. Mahmood, what is the order you are expecting from this court if your argument is to be accepted? To pay you some amount?
Pay me compensation.
That cannot be done, you know.
At the
it.
market rate with 9% interest.
My lord, that I will leave to your lordship. But thing is this, my lord, what my learned friend has read, that is opposite to, it is afterthought, my lord. Forever, lordship, kindly come to 179 page 179, kindly see. How they are afterthought. Well, this affidavit of DC are afterthought. Kindly see, page 179. It is dated 26/8/2013, my lord. Documentation 179. To the project director, it is written by Deputy Commissioner. This letter and his affidavit quite contradictory with each other. How they are playing with ordinary citizen, my lord. Regarding submission of proposal of land acquisition in 1962 of Borpeta Road town under Barnagar Revenue Circle. So many letter numbers are there, my lord. Then, sir, with reference to the above referred letter, it is informed you that the land acquisition matter in connection with land acquisition in 1962 of Borpeta Road town area under Barnagar Revenue Sarvok of Borpeta district was not dealt with by PWD roads. Wings of state government, so clarification, confirmation about details of records sought by you cannot be obtained from the PWD government of Assam. It is pertinent to mention here that by this office, letter number so that it is already informed you that the gazette notification could not be ascertained as the land in question was acquired 49 years back. Moreover, so far as assigned type of ascertain the type of land and owners, others of the land is concerned, the Jamabandi which has already been submitted. Lordship, Jamabandi means record of right. Submitted to you are vital documents and said document itself reveals that land in question was acquired for construction of National Highway 31 old. Moreover, the letter dated so-and-so issued by the circle officer, Barnagar Revenue Circle, Sarvok, enclosed along with office letter number so-and-so dated so-and-so clearly reveals that the land in question was pending and the said land has been made Sarkari after acquisition. Lordship. Now he said perhaps it is paid, how he says. Then Lordship kindly see what are the records. Then Lordship will kindly see last para. In the contract as mentioned above, the proposal of land acquisition in 1962 is written herewith for placing the same before the concerned high authority for appraisal and according compensation proposal. Enclosed, Lordship. Enclosed, Jamabandi, madam. This is the land of our records.
Then what is the position of the NHA? What is your stand?
We have filed affidavit in opposition in this petition, my lord. Their stand our stand is very small. We have lordship may only kindly Perus 64 affidavit start from my earlier for analysis. Under above fact and substance, it is clear that the land in question for NH 31 is acquired by PWD NH division. In the year 1962, NHA had only taken charge over the said land in 2005. And during handing over, no documents have been handed over to NSA regarding the compensation paid to the affected person which acquiring the land for purpose of constructing national highway. Hence, NSA is not responsible for and liable for payment compensation to petitioner as the said road in question was acquired by PWD NS division, not by NSA. That is our stand.
Add two after that. Yes.
Our stand is on my lord on behalf of NSA. That
Your standing was that this PWD National Highway Division has acquired the land and you were.
Yeah, that is our stand, my lord.
The year 2005
Yeah.
only, so you are not.
Yes, that time piece of land was with the PWD NS division.
And as per the land record, it was that becomes the certain land. That's why I did not do anything to.
Now it is whatever
It is yours then.
even if the compensation is to be paid, it is the responsibility of the state and not of the NHA.
That fine. Now the lordship will decide now, I don't know, because we are also using, off record I'm saying, because we are using the land now. That's our stand.
कंक्लूड करें इसमें मुझे जो दिख रहा है जितना डॉक्यूमेंट है उसके बेसिस में इनका नाम तो राइट राइटिंग पोजीशन एस्टैब्लिश होता है तो डेफिनेटली द क्वेश्चन ऑफ दैट और इनका स्टैंड है ये रिकॉर्ड नहीं है दे हैव कम द डिले ऑफ 45 years there is no proper explanation given so existing requirements whether they are not the land and the question of granting relief can be verified.
Yes.
It's all, only 2 points as a matter of reply, my lord. My lord, may I kindly see page 173, my lord. This is the letter of National Highways Authority of India. Regarding proposal of land acquisition 1962, case of village Borpeta Road under Bornagar Revenue Circle.
Yes.
So, Lordship may kindly see the bottom 3. It was also stated that it is an old case of 1962 and dealt by the State PWD Road Wings Department. Moreover, sufficient and essential documents pertaining to land acquisition are not available with NHAI, and State PWD did not hand over any land acquisition document at the time of taking over the NH Roads Division. Lastly, Lordship may kindly see page 174, para 7. In view of the above, proposal of this 1962 land acquisition case is forwarded herewith for your needful action, please. Then Lordship would kindly see page 176, my lord. This is also from NH. Here, second paragraph, Lordship would kindly see. The state level coordination committee during its meeting under additional subsidiary decided that concerned PWD would resolve the issue which pertains to year 1962. Decision of the additional subsidiary was also communicated to the Deputy Commissioner Borpeta. It has been reported that some local residents of the area are now claiming compensation for land acquired for NH 31 through district administration. Since the matter is pretty old, dating back to 1962, I would request you that the PWD Assam may be advised to resolve the issue as per decision taken in SLC meeting held at Guwahati under the additional subsidiary Assam. Similar letter, Lordship may kindly see page 177. So prayer, Lordship would see para 3, 177. Under the above circumstances, it is requested to take up the matter with the state
We
PWD.
understand it. We have already clarified it since they have.
Now, Lordship, yes. Now, Lordship would say, my last points, my lord, that it is page 179. It is the letter written by DC to the project director. Here, Jamabandi, Circle Officer report certificate 3 seats, 179. Then Lordship would say
179.
180, Lordship kindly see, 180. This is Deputy Commissioner, 180.
Yes.
Here, my lord, Jamabandi, 9 seats. Circle Officer report 2 seats. Certificate 3 seats. 1 seat, that is test map. Now, this letter is dated 26/8/2013. Lordship kindly see this. 26/8/2013, they have every document.
But they have not acquired the land.
Well,
The land, this road was handed over to them in the year 2005 only. How can you claim compensation from them? you can claim that the compensation, the authority was acquired the land in the year 1962.
No, it was taken in 1962, madam. It was taken in 1962. All the
1962, that was,
chronological
NHAI was not in picture. National Highway Authority was not in picture.
that is, that was acquired. It has been started a little later. It does not mean that our land was or not required. Otherwise, how they are making all these communications? Now, if they have acquired our land today, and if they start the work after 5 years, for that I am not responsible, my lord. I will seek only that as my land has been acquired, so I am entitled for compensation. Since there are 69, lordship, we are communicating. Of course, we have no documents settled to annex, but it is decided, it is admitted by circle officer. 62 and 69, not so much vast. Here the Bombay High Court, after 40 years, it has accepted the writ petition and provided relief to the aggrieved parties. Now, lordship, similarly, I would kindly say now page 183. Lordship, this is very important. 183. From Dr. S. Singh, IS, Deputy Commissioner, Borpeta, to the Additional Chief Secretary to the Government of Assam Revenue and Disaster Management Department, this one. Submission of report regarding non-payment of compensation of land acquired during 1960 for construction of National Highway 31 under Borpeta Road Town of Borpeta District. Now, Lordship, kindly see the last 2 lines. The report suggests payment of compensation to the affected patadars subject to submission of indemnity bond. That is the report, that it is written by the DC on 29/11/2013. And inquiry report is also, my lord, it is 15, it is page 184. And my lord, it is clearly stated everything. And operative portion, lordship, kindly see page 186. This is ADC's report. Under the above circumstances, page 186. Under the above circumstances, payment of land compensation may be considered to the affected patradars of village Borpeta Road Town area under Bornagar Revenue Circle, subject to submission of affidavit indemnity bond stating that they did not receive any compensation of the said land and refund the same if it is proved that they or their predecessors have received any compensation of land in 1962 or later. So the government is also not sure whether they have paid or not. So they are responsible government, they cannot say, and we are ordinary people, from us they expect everything, madam. So that I leave your lordship's wisdom, madam. So similarly, this notification of 2014, all things are there in our favor. Then, my lord, kindly see 193. Yes. 193, that is our legal notice. Where all these communications in our favor, but no payment was made, we issued a legal notice. That is, my lord, 5/3/2015. As soon as, my lord, they received our legal notice, hurriedly they passed the impugnment order, that is page 196. Kindly see. It is 10/3/2015, they have passed the impugnment order, and we sent the notice on 5/3/2015. That means immediately when they got our notice, they act and they hurriedly passed the impugnment order.
So what's wrong in that? If they
Wrong?
pass this order after 2 years.
My lord, Honorable Supreme Court has said,
If they
have
passed this order after 2 years, so it would be okay then.
no, man, I have not done that. That is,
If
they were also big.
If they have
My
decided
lord,
your case, after
there is
receiving
a-
notice, what's wrong in that, sir?
My lord, what is my humble prayer, my lord? Of course, lordship would decide the matter, but there is a judgment of our Supreme Court that bureaucratic delay and red tapeism. Now they are delaying the matter. They cannot take the benefit of their own riches. This is reported case, my lord. That is 2003 5 SSC 333 para 7. Bureaucratic delay and red tapeism cannot be a ground of taking some benefit by the government. They are delaying. They are communicating, should pay, indemnity bond, affidavit, etc. Everything is in our favor. All of a sudden we send the notice, they say records are not there. But other day, this is at every records. So lordship will kindly seek their conduct also, madam.
Yes.
So my lord, my humble prayer is this, and we are very much, we have become poor because that was the source of our income. And our land is, my lord, 11 bigha, that in that letter, there are other person, our land is 7 bigha, 4 katha, 17 lesa, which are to be, our prayer is this, 2 persons are here appellant for the power of attorney holder, Rina Mondal and Amar Chand Mondal. Their names have been substituted by this honorable High Court.
Power of attorney holder.
They are power of attorney holder.
Why? Why the
Because
petitioners are not approached on their
there are
own?
so many persons, my lord, many of them have almost lost their hope that in this manner, lordship, everybody do not think alike. My lord, I have a very good case, man. Though there is delay.
Certainly, you have very good case and they are
Though
also
there is
saying that
delay.
very good case it is.
But delay
It is for
cannot,
us to decide
my
which case is
lord,
good.
delay cannot take away the substantial right, my lord. 7 bigha, 4 gata, 17 lesser land. And that too, within the
Just a minute.
highway.
So, these power of attorney holders are whom?
Rina Mondal and Amar Chand Mondal.
Who are they?
Rina Mondal is the wife of Amar Chand Mondal, and the daughter-in-law of late Hemanta Kumar Mondal. Late Hemanta Kumar Mondal.
And she is
And
no
Amar
more.
Chand Mondal,
And she is no more now.
the Rina is alive.
No, I think so. In the one of the order sheet is legal representative.
No, almost majority of them died, brother. Thereafter, their sons and daughters. So this is the irony of fate, my lord. And their sons and daughters have executed a power of attorney in favor of Rina Mondal and Amar Chand Mondal. So these things are going on. Now, my lord, my one last submission is this, my lord, that if your lordship is on the view that our lands were not acquired, then my lord again may verify. We have no objection.
Still,
We are honest person, my lord.
then
Again, lordship may kindly examine through high-ranking officer that whether our lands were acquired or not. If there is a slight doubt,
still we have not made up our mind. We'll consider it. Then
but I am before High Court, my lord, I want some high-level relief, my lord.
I want high level relief. What do you mean by high level relief?
Supreme Court, supreme level relief on this.
Then why are you opting for this high level relief? You should opt for supreme level relief.
Because we have, at present, we have no alternative, my lord.
Report of the passage of my lord, the appellant has preferred it, my lord, claim this, my lord, the report of circle officer. This is not in the official letterhead, page 159. This is the basis and foundation of the case projected by the petition.
159.
159. It is the report of the circle officer. It is not the official letterhead.
Then
Therefore.
And that has been, my lord, reflected in the
159, no?
and the observation was also made by the learned legal judge.
Yes.
It will also verify.
Arguments heard. Judgment reserved.
Obliged.
My lord.
Item 21 to 23.
Obliged.
Made to the lordship. This case is relating to my lord appointment of distributor for rural area for LPG distributor. On advertisements were made, my lord, and responding to that advertisement, many persons, my lord, applied, but there is a condition, only the local person who is a voter of that area for that and under the Gram Panchayat, they should be entitled, my lord, first. If there is no, then, my lord, there are other two conditions. Here, my lord, the learned single judge has in detail, my lord, has written the judgment. He was kind enough to set aside the in earlier order, my lord, the appointing the distributor order, respond number 4. But, my lord, I'm agreed in spite of, my lord, setting aside the implement order, because, my lord, the learned single judge has not, my lord, directed any issue, any direction to appoint me as the distributor. But there was, my lord,
Again,
yes,
such a direction can be given when there are more than one.
Yes, my lord.
two
I am
applicants
the
or more
only-
than one applicant. If there are two applicants, certainly we would have
yes, my lord. Yes, I am coming to that, my lord. Number 1, I am the only resident of that area in the
That is to
application.
be seen again.
And I have approached the court. Nobody has approached the court. They are fence sitters. They have not approached the court.
Can't be there. That can't be the
And
ground
there are
for,
violation of particularly 3 points, my lord, that the selection of the petitioner is set aside in violation of the relevant guidelines.
Yes.
Number 1. I'm coming to that, my lord. The law relates to the guidelines, my lord. Election is at page, my lord. In the judgment is felt, my lord. At page 247, my lord.
Yes.
Clause 10.4.2 is very relevant for the purpose of instant dispute, and the same is quoted hereunder. That one application per applicant for a location. Applicants should submit only one application for one location. In case more than one application is received from an individual, all the applications would be clubbed together, it should be clubbed together and treated as one application. In such cases, application fees received against all other applications would be forfeited. That was the condition. So on that ground, they should not have, my lord, cancel my
They have not cancelled
application.
yours.
Huh?
They have not cancelled yours.
Private, they have earlier application, they have cancelled. That will come from the affidavit filed by the ISL authority, my lord. Then your lordship will come to page 126. It is their affidavit, my lord. I'm reading from page 127, paragraph 4. Got it, my lord? 127, paragraph 4, that with regard to the statements made in so-and-so, that petitioner submitted 2 online applications, file number so-and-so, so-and-so. As per unified guideline for selection of LPG distributors is October 2017, plus 10.4.2, only one application per applicant is allowed for a single location. In case more than one application is received from an applicant, all the applications should be clubbed together and treated as one application. Also, in such cases, the application fees received against all other applications would stand forfeited. As the scrutiny of applications was done online, the online system could not detect the submission of 2 numbers of applications by the same applicant, Sri Dayal Chandra Pal, as he had mentioned his father's name and title differently in both the application number so-and-so and father's name had been stated as my lord Santosh Paul instead of my lord Pal. So he had mentioned it as Santosh Pal. There's a typing mistake of missing the adding the U, my lord. It should have been Pal, my lord. No, Paul, my lord. It should have been Paul. The U was missing. Then, my lord, that next para, statement made in so-and-so, that's that the petitioner was selected for the first job lots, which was held on so-and-so, on which Sri Dayal Chandra Pal was declared as the selected candidate for the location Jamlai, and after his selection, certain verbal complaints were raised by other applicants who were present on the date of draw, stating that the petitioner has applied twice and as such his candidature should be cancelled. Later on, a formal complaint was also received on so-and-so from one Srimati Nandita Das. She is a resident of Bharanamukh, my lord, against the selection of the petitioner, stating that he had applied twice. The matter was thus examined by the authorities, and it was found that the allegations raised in the complaint so-and-so was true. Accordingly, the petitioner's selection for the Jamlai location was cancelled against the application number so-and-so, and he was informed about the cancellation of the application. I have not received any letter, my lord, regarding cancellation.
Acha, not yet.
And
Conclusion of that thing, let's put the Jamaica,
हाँ, इसमें जो इंटरिम ऑर्डर है ये भी थोड़ा नॉट ओके है। उन्होंने कहा है कि चलो क्वेश्चन नंबर 4 वाला जो है बाकी जो बचे बचे एप्लीकेंट्स कंसिडर करके नहीं मुझे ही तो नहीं। Where is the prayer portion of your writ petition?
Yes.
Which page?
There are two writ petition, my lord.
Your writ petition.
Yes.
Earlier one is gone.
Beg your pardon?
Earlier one is gone.
Yes, earlier one is.
The one where you
Second,
challenged
yes.
respond number
Prayer-
4
prayer
selection, that is only live.
prayer, your lordship will kindly come to the prayer, page 95, my lord. Page 95. Because the guidelines, my lord, they have owned their guidelines and they have violated their own guidelines by rejecting my lord first one. Page 95. There are C, my lord. Other the petitioner being eligible
Other applicants are not.
amongst other candidates.
Applicants are not parties. Other applicants are not parties. Only the selected candidate.
I have gotten now, my lord, the voter list and my lord, a certificate from the government, sir. The others who have applied, they should have put in it sincerely. When in the guidelines, there is a clause, my lord, that one should be resident of that, my lord, village. But my lord, they are not even voters of that area.
Person is also preferred. हाँ वही है। Item 22.
Typically, see, my lord.
Why the writ petition is
95C.
tagged? Writ petition is not disposed of.
Dispose of, my lord.
WPC 5718 of 2000.
Dispose of.
But this petition, my lord,
That's what it is.
my lord,
So the respondent number 4 in the earlier round has also preferred a writ appeal against the judgment.
Lordship, my readable,
Once we have complied with the contract cancel, he has now come up with the.
That is Mr.
Lordship.
Dia's client.
writ appeal number 262, item number 22, is was filed earlier, my lord. And thereafter, this writ appeal 325 my writ appeal filed earlier, filed on 27/6/2023. And now, my lord, within this, when matter was subsidized before this honorable court, pendency of this writ appeal, this subsequent, my lord, termination letter issued by knowing that writ appeal already been.
So how,
Right.
is there any stay in that writ appeal?
But
In my case.
notice was received by the
So how, even though if the notice was issued and there was no stay,
Yes,
What's the wrong
But
in the
but
action of the
that
respondent?
termination, my lord, that termination
Considering
letter,
your, Candidature or terminating your.
and
LOI.
that lordship, that termination letter saying in writ petition number, my lord, item 23,
Yes,
page 78, regarding relevant factual background, saying in my favor, nothing against me. IOCL has supported my case. Lordship. IOCL has supported my case, my lord, in my writ appeal, my lord, item number 22, kindly lordship.
that doesn't mean once the court has ruled that your selection and appointment as a dealer is in violation of the 11.16 condition, that is there and in
But-
pursuant to that.
but lordship,
Just a minute, listen, Mr.
Lordship.
And pursuant to that, they have already issued a termination order, which is under challenge before the, in the writ petition. Let the writ petition be decided, Baki, all these, the appeals. We don't find any point in continuing with these appeals.
And lordship, there is a, my lord, I have, my lord, standard residence certificate, my lord. That is.
Suppose, Mr. Concept, if we pass any order on merits in your appeal, writ appeal, then certainly that would affect your merits of the writ petition also. So you want any order on merit?
Lordship, it may, my lord, segregate. If,
That is already there pending.
lordship, writ
Don't know why
petition.
it is tagged here. with
This
this
petition, my lord,
writ appeal.
I pray because, my lord, there is similar issue, my lord. So far, my lord, the affidavit filed by the IOCL supported my case. They're saying, my lord,
Whether they have filed any appeal against the impugned judgment?
I filed appeal.
You have filed, IOCL has filed any?
No, no, no.
Then
have not filed.
they have accepted that judgment.
But question is, my lord, their affidavit in opposition, my lord.
Even though affidavit in opposition, even your writ, all are saying one thing, but if the court has decided some otherwise, then how IOCL is bound by their affidavit?
My lord, question is, my lord, so far, my lord, intercept priority list, my name appear, that has not been challenged. Page, my lord, 49, kindly have a look, lordship.
What?
Because
49?
I my name also covered under list 1. Because I have a standard residence certificate, and that standard residence certificate has not been challenged. That was issued by the circle officer. That was not challenged in the writ petition.
How the learned single judges dealt with that? Read.
In my writ appeal, my lord, 262, my lord. Kindly, my lord, page 49.
Record clear.
Here, my lord, the intercept priority list, applicant found eligible. So I was found eligible.
Sir, how the learned single judge dealt with this? All these your arguments, please refer to those.
Impugned judgment, my lord, 207, my lord.
The relevant para.
Relevant para, my lord, 211 page, my lord, plus 5.
Para 5.
Para 5, my lord. Plus 10.4.2 is very relevant for the purpose of instant dispute, and the same is quoted here in that. One application for per applicant for a location. Applicant should submit only one application for one location. In case more than one application is received from an individual, all the application would be clubbed together and treated as one application. In such cases, application fees received against all other application would be forfeited. And now, my lord, so far, clause 11.6, my lord. Intercept priority is given in the draw of lots to the eligible applicants for the Durgam Khetra Bitrop location wherein 3 priority lists will be prepared as per the following order. List 1, eligible applicants residing in the concerned Gram Panchayat of the advertised location. So I was, my lord, residing at the concerned Gram Panchayat. And so far, my lord, this is
So your case is that you are falling in the priority number 1.
1, my lord.
And what is in support of this contention? What documents you have referred
Lordship,
to?
page
And how the learned single judges dealt with those documents?
Lordship, page 132, my lord.
Leave it.
Yes.
You just refer to the findings of the learned single judge.
So first time coming to the my standard residence certificate, my lord.
Sir, you
Yes.
please, first you please refer what the learned single judge has observed, then only we'll go through that
Lordship.
residence certificate.
My lord, page 216, my lord. It is also admitted.
Para number.
The page 216, my lord. First para, my lord.
Para,
It is, my
the
lord.
para number of the judgment, sir,
Para number, my lord, 15.
15. Now read.
From the record of writ petition number so and so, it reveals that an affidavit in opposition was filed by respondent number 1, 2, 3 on so and so. In paragraph 4, it has been mentioned as to why the first draw was cancelled in view of the 2 applications filed by the petitioner for the same location. In paragraph 5, it was mentioned that in the next draw of lot held on so and so, the respondent number 5 was selected, wherein the petitioner had also participated. It was further mentioned that as per the unified guidelines, it is not mandatory for a candidate to be a permanent resident of the Gram Panchayat. And also there is no stipulation of years about living in the Gram Panchayat. It was further mentioned that no proof her resident status, the selected candidate has to produce the standard residence certificate, which the respondent number 4 has rightly submitted before the field verification. It was further mentioned that the field verification committee, at letter dated 3/1/2019, requested the circle officer, Nagarbara Revenue Circle, to confirm the standard residence certificate of the respondent number 4. In reply, the circle officer, Nagarbara Revenue Circle, had written a letter dated 9/1/2019, confirming the residential status of respondent number 4 as a leased residence since 4/7/2018 in the house of Abdul Gabbar, and further stating that the number 42, Jamlai Gaon Panchayat, Kallanpur Gaon Panchayat, and Jamlai Kallanpur Gaon Panchayat are the same, which means that the respondent number 4 was a resident of the advertised location. And it's Gram Panchayat. It was on the basis
Mr.
of the
Counsel, please come to para number 22 of the impugn judgment.
22. Proceed. From the above materials on record and upon hearing the land counsels appearing on behalf of the parties, the question arises as to whether the respondent number 4 ought to have been placed in the inter-se priority list 1, wherein the eligible applicants residing in the concerned Gram Panchayat of the advertised location were clubbed together. The record reveals that on 12/6/2018, the advertisement was issued. The advertisement categorically mandated that in terms with clause 11.4, read with clause 11.6, certain preference would be given for DKB location on the basis of residence. Clause 11.6 as quoted herein above would show that those eligible applicants residing in concerned Gram Panchayat of advertised location would get preference over those eligible applicants residing in the concerned revenue subdivision of the advertised location who would come under list 2. It would further show that those eligible applicants who neither reside within the concerned Gram Panchayat nor in the concerned revenue subdivision of the advertised location would be grouped in list 3. The documents on which the respondent number 4 herein claims that she comes within list 1 is on the basis of an unregistered agreement for lease entered on 4/7/2018, that too for a vacant plot of land. The other document on which the resident, number 4, claims to be resident as registered deed of lease dated 12/7/2018, just on one day before the last date of application. Further to that, standard residence certificate issued on 21/11/2018, as well as circular officer report on 9/1/2019 are all based upon the unregistered agreement for the lease dated 4/7/2018. It would therefore be seen that only pursuant to the advertisement, the respondent number 4 has taken steps to enter into the agreement for lease of the land and thereupon submitted the application on 13/7/2018. This is wrong, madam. This is wrongly stated.
Please, leave.
Strangely enough, in spite of various statements being made by the petitioner that the respondent number 4 is not a resident of the Gram Panchayat in question, there is not a single document placed on record. For example, the voter ID card and other card or any other document issued by the statutory authority showing the address of the resident respondent number 4 prior to 13/7/2018 to be a resident of the advertised location. Even the document placed today before this court by way of additional affidavit is not a document which was submitted during the process of consideration of the respondent number 4. There was also no reference to the said document in the affidavit in opposition. Under such circumstances, the question therefore arises as to whether the respondent number 4 could have been brought within the purview of list 1 of clause 11.6. In this regard, this court finds it relevant to observe that by an order dated 35/2023, this court directed the respondent IOCL to file an additional affidavit stating the reasons why clause 11.6 was incorporated in the guidelines. Strangely enough, the respondent IOCL did not care to file the said affidavit.
Yes. Read further.
Be that as it may, this court finds it relevant to take note of the judgment of the Supreme Court in the case Bhagavan Das and another versus Kamal Abrol and others reported in 2005-11-66. In the said case, it was also relating to allotment of retail outlet for distribution of liquefied petroleum gas (LPG) by the Hindustan Petroleum Corporation, and which is one of the constituents of the advertisement dated 12/6/2018. The Supreme Court dealt with the aspect of the resident and observed that the word residence is generally understood as referring to a person in connection with the place where he lives and may be defined as one who resides in a place or one who dwells in a place for a considerable period of time as distinguished from one who merely works in a certain locality or comes casually for a visit, and the place of work or place of casual visit are different from the place of residence. The Supreme Court observed that there are two classifications of the meaning of word residence. First is in the form of permanent and temporary residence, and the second classification is based on de facto and de jure residence. The de facto concept of residence can be understood clearly by the meaning of word residence as given in Black's Law Dictionary in edition, meaning thereby that the word residence means bodily presence as an inhabitant in a given place. Thus, a de facto residence is also to be understood as the place where one regularly resides as different to the places where he is connected to by mere ancestral connections or political connections or connection by marriage. The Supreme Court, taking into account the eligibility criteria for allotment of LPG distributorship, further observed that what is required to fulfill the eligibility criterion on residence is that the person should be a de facto resident and not have a mere connection with the place on account of her husband having some personal or ancestral property in Kangra.
Next.
In the backdrop of the above, it is seen from the pleadings of the petition that in the affidavit in replies where it has been mentioned that the respondent number 4 is a resident of village Gopalpur, post office Mirza in the district of Kamrup, there is no denial to the said aspect. On the basis of documents shown on record, it would be seen that only after the issuance of the advertisement on 12/6/2018 that the respondent took steps for the purpose of getting within the purview of list 1 by entering into agreement of lease for lease on 4/7/2018 and a registered agreement for lease on so and so, just 1 day prior to last date of submission of the application. In this regard, this court finds it relevant to quote paragraph 12. My lord, lordship, question is, my lord, for my residential establishment, I did not enter into agreement, lease agreement, my lord. That is, my lord, so far it is, my lord, one of the criteria for eligibility laid down in the prescribed format, my lord. That is, my lord, page 141, my lord. Kindly have a look, my lord. It is wrongly narrated by the learned single judge. Page, my lord, 141.
Mr. Bhuya, you have asked for refund of your security deposit, which is recorded by the learned single judge. After that, how can you maintain this appeal?
My question is, my lord, so far, my lord, priority list concerned, and so far, my lord, standard residence certificate is concerned, I am within the purview of list 1. And my lord, so far, my lord, this my application is concerned. Page, my lord, 141. Kindly have a look for a moment, my lord. Page 41, 141. Page 141, my lord. This is the standard application, prescribed application, my lord. Here, my lord, it was provided.
So has she asked for this security money?
My lord, one thing, my lord, for my lord.
Now, Mr. Bhuya, please, what documents you have filed along with this writ petition to claim that you are the resident of that area? You just show us those documents. What documents you have annexed with the writ petition or with the affidavit in opposition that you are the resident of that area? Show us.
Lordship, page 130, my lord. 130. 130, 130, my lord. One 130, my lord. This is standard residence certificate. Issued by circle officer, my lord.
130.
130, my lord. In my writ appeal, item number 22, my lord.
In your writ appeal,
Lordship.
you just show us from this record of the writ appeal.
Yes, my lord. It is also my writ appeal, item number 22.
No,
it is also writ
this
appeal.
writ appeal, where is the document? In the present appeal.
Two writ appeal, my lord. One file from my side, another file by writ petitioner. And item number, my lord, 21.
Yes, 130, yeah.
Item number 130.
Standard residence certificate.
This is to certify that Srimati Dipti Das, daughter of so-and-so, wife of so-and-so, village Damlai, under 42 number Damlai, Kalyanpur, Gram Panchayat of Nagarbera Revenue Circle, Block Somoria, Subdivision, Boku, District Kamrup, State Assam, since 4/7/2018.
And the last date for application is? Huh? 13/7/2018.
It is, my
So
lord.
you started residing in this village on from 4/7/2018.
And on 4/7, my lord, because, my lord, this standard certificate during the field verification, it was furnished. During the field verification.
Verification, this is what the document, this is your trump card.
My lord,
Standard residence certificate, this is your trump card. that you are resident of this village, this
But
is your trump card.
I am not claiming that I am a permanent resident of this locality,
Then
but I am permanent resident of uh, here, my lord, so far my application is concerned, my permanent resident, everything mentioned, my lord. Is but advertisement doesn't say permanent resident, only saying the resident.
resident.
Resident is enough.
Yes.
And I have said also stated in the affidavit that permanent residence is not mandatory.
Fine.
And regarding my citizenship is no doubt. I am citizen of India. And so far, my lord, my application is concerned. My application, nothing, my lord, fabricating, nothing, my lord, suppressed, because my application clearly saying that I am resident of I am resident of, permanent resident of Gopalpur. This is, my lord, I have shown. And so far advertisement, my lord, application, here, my lord, it is provided, page 142, that applicant should own LPG godown or constructed LPG godown, own or registered lease deed for minimum 15 years in the name of applicant, member of family unit, commencing on any date from the date of advertisement up to the last date of submission of application. So prior to submission of application, last date was 13/7.
And advertisement
And
issued
I
on
was-
which advertisement was issued on which date?
12, my lord, on 12/6/2018.
12/6/2018.
Yes, lordship. And I enter into register lease deed, my lord, on 12/7/2018.
Last date was 13/7.
Yes, but it is provided that from the date of advertisement up to the last date of submission. So last date was 13/7, and on before 13/7, on 12/7, I enter into
Or you
lease
are
deed.
permanent resident of which area?
Permanent resident of, my lord, Gopalpur. Gopalpur, PS Polasbari, my lord, and
It falls within the revenue
subdivision, my
circle.
lord, subdivision, that is
It falls within the revenue circle. Revenue circle.
revenue, sir.
So ideally, if as the resident of Gopalpur, if you would have filed any application, then you will be you would be treated in category second.
Second. Then I will be category. Same reason. But so far, my lord, I am residing thereafter, my lord, here and enter into register lease deed for the period of 15 years. And this, my lord, residence certificate has not been challenged. Residence certificate
So
has not.
these are the certificates. This annexure 5, appendix 5 is the annexure 5 is the trump card. And later on, the other lease documents and all of 12/7, and these are the supporting documents.
But this, my lord, standard residence certificate has not been challenged and it has not been set aside.
There is no question of challenging that.
What question is, my lord,
There
this
is
is
no
this is
question of
enforced,
challenging
my
that.
lord. This is enforced, my lord, and my lord, the respondent 4 in this writ appeal and appellant in item number 21 had participated in the second selection process. When first selection cancelled, that cancellation order has been
तो इनका कैंसिल हो नाम जस्ट जब कैंसिल किया न्यू फाइल किया दोबारा जो उसमें भी न्यू फाइल हाँ your client had filed a writ petition initially.
Yes.
Agreed by the original cancellation, is that correct?
no.
No, my lord.
Cancellation
Originally,
has
I
not
could not
challenged.
get the letter of intent. Originally, when I filed the petition, we could not get the letter of intent.
No. How many writ petitions did our client file? Only one.
Two writ
So
petitions.
that's what I'm saying. Which are the two?
The,
5, 7, 8,
this,
7.
the 2 writ petitions.
Yes.
Right. Originally,
First writ petition is in relation to what?
The first petition, UI was not on the child. He came to, but we find the affidavit for that.
No. We are asking about this respondent.
Where is quite different?
The private respondent has filed a writ petition after the impugned judgment was.
Earlier, she has not filed any petition. Deepti Das, na?
Yes.
Only defended her.
after the judgment, she has filed a writ.
Deepti Das has defended her claim in the writ petition
Yes.
filed by this appellant. And after the judgment, you have cancelled her selection, then only she has prepared this writ petition. No, but what about this earlier draw was cancelled, draw one for the. Okay.
That was my lord's.
The reason for cancellation of the earlier law.
Made known to her, we have served her a notice that it was on the time.
He didn't receive any.
Yes.
He didn't receive any order, my lord, cancellation order, but finding no out, my lord, he have applied it again. So as he has second part in the second
So
also,
Mr.
he cannot challenge.
Just a minute. Mr.
2 points I
Yeah.
want to submit, my lord.
Now you are ready to take risk of this observation by this court in the writ appeal in respect of your residence?
Worship resident.
You are ready to take risk since your writ petition is still pending.
Worship.
You are ready to take this risk?
And my humble submission, my lord, so far, my lord, item number 21 is concerned. And the appellant. Lordship, one thing is to be noted, my lord. Lordship, one thing I would like, I would like
Counsel
to.
for IOCL, please. This para number 12 of the impugned judgment, it speaks about which writ?
There were two petitions filed by. First, the LOI was not on the child. That's why they both of them were tagged together.
In the first writ petition, LOI was under challenge.
It was not for challenge.
It's not.
And in the second writ petition,
Hello.
The calculation of the LOI and the second.
this, the unsuccessful respondent number, this unsuccessful candidate who has not been selected, this Dayal Paul, he preferred writ petition number 5787/2019 for what?
It is here, my lord. I may read the prayer.
Notice of appointment of the.
For the list dated 5/11/2018.
Freelance client, okay, उसमें में LOI. उसमें LOI. Maybe say the I thought she was arguing not in a fair population. Unless they have challenged. I thought.
And lordship,
Acha, Mr. Bhuya,
lordship.
what happens to Mrs. Saikya's appeal, we'll see. But if you succeed in the writ appeal, it's fine. If you don't, then it will have multiple repercussions for your client. First of all, your writ petition goes, and you will not have a forum to challenge, except this apex court. Secondly, your claim about residency will be in serious cloud. Now that you have filed a writ petition, which is pending, you have the option of either withdrawing the appeal and pursuing the writ petition. Or if we pursue the appeal, then if it goes against you, it is over for you.
I will withdraw the writ petition. I will withdraw the writ petition.
No, you can't withdraw the writ petition. You have to withdraw the writ appeal, because if the writ appeal is dismissed, your writ petition goes automatically. There will be nothing in that.
But in the writ appeal, my lord, I challenge the impugned judgment passed by the last.
That will go. That's the problem.
That's right.
Because, my lord, only the issue, so far my residential status.
Suggested that if you succeeds in this writ appeal, it's okay. But if any orders, any adverse orders is passed to you in this writ appeal, then that would result in dismissal of the writ petition automatically.
Worship.
So you are ready to take
No.
this risk.
Now, question, my lord, if I am not getting the favorable order in writ appeal, then ultimately, my lord, my writ petition also will null and void, will not get any benefit. So, my lord, I pray, my lord, in this writ appeal, on the basis of my lord, standard certificate that has not been challenged. And so far, the two writ petition filed by my madam client, and nowhere my appointment letter as well as memorandum of agreement has not been challenged. Either of the writ petition, my appointment and agreement with the IOCL has not been challenged. And cancellation order, my lord, cancellation order has been accepted. That is dated 22/10/2018. Received on 24/10/2018. And after accepting this cancellation, had participated in the second draw. And he cannot be agreed now, when I am being selected as lucky winner. This is the case, your lord. This is clear, my lord. He had participated in the second.
May I be allowed to submit few points, my lord? Number one, my lord, from the judgment, my lord, paragraph 17. It is ample clear, my lord, that the certificate given by the circle officer, page 286, my lord. 17 of the judgment, 286. That it further reveals from the records that an affidavit reply was filed by the petitioner, wherein drawing reference to the communication dated so and so issued by the circle officer Nagarbara, it was given to the government advocate actually, my lord. It was mentioned that the respondent number 4 was not a permanent resident of the locality, and she was not a voter and not having any NRC details to establish her permanent residency of the advertised location. It was further mentioned that the respondent 4 was a permanent resident of village Gopalpur, post office Mirza of Palasbari. Then I would like to place the letter, my lord, of the circle officer, page 267. Page 267. It is written to the senior government advocate. Additional senior government here. The circle officer.
No, but why are you arguing these things? The learned single judge has held that she is not a
Yes,
resident.
my lord.
Then you want that finding to be
No,
satisfied?
no, my lord, only established. No, he is
The
telling. my
question
lord,
of, see,
yes,
the,
for your lordship's satisfaction.
listen, the tender condition mentions very clearly, selection will be only on draw of lots.
Yes.
So once the respondent numbers 4 selection has been set aside, and there being more than one candidate,
Yes, sir.
the learned single judge has said that now hold a fresh draw of lot. There's nothing wrong with that finding. There
Regard-
can't be a mandamus to appoint you. Question doesn't arise.
Second, my lord, the village people, so many village people also given an application to the authority that she is not
No,
a
that we are not
resident of
concerned.
the.
That but you plead your case.
Yes, sir.
How you are
My case
entitled
is,
for
my lord,
leadership
I have,
in
my lord, that in misinterpretation of the guidelines, they have cancelled the first selection, number one. Number
which
two,
first selection?
I have not challenged the second selection because I have also again taken part. It is the established law of the Supreme Court that once you have taken part in the selection process, you cannot challenge it.
That's everything over. That is
So
over.
the
That is
second draw,
over.
I didn't challenge, my lord.
Ma'am, that is over. Now you just, what you are claiming that since the selection of the respondent number 4 is cancelled, therefore a direction be issued to appoint you as a LPG dealer. What is the basis for that?
I was selected, my lord. Earlier, I was wrongly, my lord, wrongly
has
deprived.
gone. That
No,
has
my lord,
gone.
that will be there because
That
there are
has
two
gone.
officers.
Since you have
I am
participated
selected.
in the
No, my lord.
second selection,
that has gone, you have
First
waived
ele-
that.
No, my lord, that's wrongly, they have done wrongly.
Yes,
They have misinterpreted the, my lord,
they have done
guidelines.
wrongly, but
Exactly, my lord.
But since
They have
you
misinterpreted
chose-
the guidelines.
you
Your
have
lordship
chosen
kindly
to
consider.
enter into the second selection and participate in the second selection, that whatever your challenge that you have waived.
That cannot be because, my lord, I have no option. If I don't apply for the second selection also, my lord, he may deprive, he didn't know much because there are, my lord,
Whatever
this
it
is, my
may
lord,
be.
not knowing law or, my lord, they are not.
So one
some
thing is
literate-
clear that
literate
no
person.
direction can be issued for appointment
There
of
is
the
a stay order, my lord.
appellant
In my
as
appeal.
a distributor or dealer of the LPG distributorship. That can't be given, and we don't find any illegality in the said direction of the learned single judge.
Yes, my lord. One more thing, my lord, I would like to place. That the Gapan Sahib, President Gapan Sahib, he has given letter, these persons, those persons who has earlier, my lord, applied and taken part in the selection, they are none of them are voters of that particular Gapan
That
Sahib
is to
area.
be seen by the
For your lordship,
IOCL authorities, not by this court.
only for your lordship knowledge, my lord, I
No,
am suggesting this.
we are not supposed to have this knowledge, madam.
Then, my lord, that no natural justice, my lord. He was not given
That is
any
the only
opportunity.
justice.
Before
Yes.
cancellation, your lordship will give priority that no notice was issued, natural justice. That's why, my lord, interim order was also passed.
Yeah.
Because, my lord,
Yes.
no opportunity was given to him before cancellation, why you have filed to? Or that is number one, violation of the guidelines. Number two, my lord, that violation of, my lord, natural justice.
Yes. Anything
That is
else?
enough, my lord. I think your lordship to give me relief, my lord. These 2 points are very vital points.
Yes, anything else? Which come?
Lordship, I have not committed any fault. My lord. So far, my lucky draw is concerned. I was a lucky winner. And accordingly, my lord, I was appointed. And thereafter, I entered into agreement. And thereafter, as per agreement, I followed all the conditions and constructed and set up the LPG quota. I invest huge amount, my lord. And people of the Hitchcock area was satisfied. There is no any single whisper regarding my conduct.
Satisfied,
So-
still you have
so
not
question
operated
is,
that
my lord,
PG dealership.
I-
All the
I
people
filed-
are satisfied.
I filed writ petition because, my lord, so my livelihood is concerned, my lord. So livelihood is infringement because of I invested huge amount. And now on what ground I am being deprived?
Because you are not
What-
the resident
what-
of that area.
and nothing,
This is
no
the ground.
document.
Still you have not been able to understand that on what ground your
And lordship question is,
application was rejected, that
nothing,
it's
no
very
any
strange.
fabricated document I furnished. What about document furnished, genuinely furnished? By the standard certificate, my lord, issued by the circle officer, that is also not challenged. My lord. That is enforced. My lord. And so, and question is, my lord, voter and other thing is not required as per unified guideline and advertisement is concerned. IOCL will say, so far the unified guideline and advertisement is concerned, only residence is necessary. And whether voter, whether permanently residing, that is not appear in the advertisement.
Sorry, what
And
we
and
can
so
do
far,
is
my
that
lord, learned single
the Supreme Court has ruled that such type of persons can't be treated as a resident of that area who visits the place occasionally and not the permanent or not the resident of that area, de facto resident of that area, and you are not.
But that judgment, Bhagavan, that judgment is not covered by my case. That judgment is not covered my case because so far advertisement.
That is
and
your argument. That is your argument.
No, question is so far unified guideline and advertisement is concerned. I'm on that. The unified guideline and advertisement doesn't say that the applicant should have permanent resident. Nothing, only saying resident.
Yes.
That is why, my lord, I find this tricky.
Otherwise, my lord, whole process will be a mockery, my lord, because
Do you have any Aadhaar card?
court has set aside, my
No,
lord.
my lord, I am, my lord, originally, my
Do
lord.
you have any Aadhaar card?
Aadhaar card for the resident of Gopalpur,
You have that.
only few kilometer distance.
Whatever it may be, you have that. And your name appear in the which voter list of which area?
That is, my lord, Jamlai, my lord.
She's
Jamlai
not a
village.
voter, not an NRC holder.
I am
nothing
not
else.
permanent,
Aadhaar
I am
card,
not.
everything
I
all
am
depends.
I am not.
Nobody
claiming-
is staying there, my
I
lord.
am not
Only-
claiming that I am a.
Only go down. the
Madam,
question.
we are already
Yes.
in employees. You take your seat.
I am not claiming that I am a permanent resident of Jamlai. So far my application is concerned, here I have clearly narrated my village resident is Gopalpur. That is, my lord, Polasbari, my lord, and the district of Kamrup, my lord. And subdivision, my lord, that is Nogarbera. I have clearly narrated. But so far my present residential status, I have a, my lord, tenant of this locality. And tenant also has right.
Yes.
So, my lord, I am a permanent resident of Gopalpur. So far, my application is concerned. Page 141, clearly narrated. And so far, this condition, my lord. So far, this criteria of eligibility laid down in the advertisement and this application, I enter into registered list. So I am not claiming on that point. But so far, my lord, my residential status.
Yes.
So, my lord, by humble submission, my lord, so far my application is concerned, when I filed, and this application itself reflected that I am not permanent resident of the advertised location. But I am residing to the advertised location as a tenant. And there is a standard residence certificate that I am residing to that area. So, my lord, on that ground, my distributorship cannot be cancelled. And my cancellation, my appointment and as well as agreement has not been assailed, either of the writ petition.
Yes.
That is either of the writ petition not challenged.
Arguments heard. Judgment reserved in writ appeal number 325 and 262. Writ petition number 578B. Listed before the appropriate, be listed before the appropriate bench.
I love that.
Order to separate. This matter will posted.
I love that.
Well, Lordship will kindly consider that he is the only one person, only and one person from the Gapansad voter, village area. Others are not a single person. So, my lord, although some opportunity, it is the guideline or the department, my lord, they have tried to, my lord, appoint the village people, person from Porolum, person from Guwahati, person from all over, I mean, the surrounding area is taking part, and the genuine persons have been deprived. That is the thing. So I think your lordship will realize the difficulty, and my lord, he is the only one person from that village. But my lord, their whole intention is frustrated because the officials have wrongly interpreted the guidelines.
You are the only person, then certainly you will fall within the priority one, and then there will be no
Priority
option.
one, he is the only fulfilling criteria.
Then,
but others are
then
not.
100 single judges, that's all, that's why I'll issue direction that the process further and decide
Yes.
whatever the applications
My
are
lord,
there.
why he should be deprived? Others are fence sitters, because they
Then there is a question of
has not come
deprivation, still
forward.
They have not considered.
Yes, they have not come forward, my lord. Nobody is aggrieved, nobody has approached this court.
Yes.
Item 24 and 25.
So come on, today we have enough material to. deal with. Any other appropriate day.
Yes, sir. I'm unlucky today.
तारीख तक हुआ
Subject to your lordship's convenience on 19, Tuesday.
19, Tuesday.
18, 19, 20, I'm at your lordship's disposal.
Let it be 18, Peter.
22nd more Supreme Court case.
अभी 2-3 दिन में मैंने मेरी के साथ रिपोर्ट ले गया
इस तरह असर नहीं इस तरह
18, 19,
These-
mistake.
these
Abhi
studies-
sab- any convenient date in April?
इस तरह पड़ेगा
April. Department is suffering. Public road, my lord.
The public road, it's a public road.
April अच्छा है.
Sir, can have it on 20 my lord.
इन्होंने दिया था plan.
But department has not opened the financial bid as yet of their own. Undertaking was given by you.
ये है कि
So financially.
This tarikh
First, second, if your lordships, my lord. First or second April, my lord.
March. 14th March. Yes, yes.
14 असूल नहीं?
I'm there.
My lord, up to 15 I'll be in Delhi.
After 15 you will be there. 14 comes before 15.
after 11. 11 to 15.
11 to 15, that week I'm made.
18.
Then 18.
18.
18, my lord.
20.
But 18 will take a chance if your lordships, where we are unlucky on 18, then your lordship will again look into April, my lord. 9 is 18. 18 to 9. 18. 18, my lord, will take the chance, my lord. If for some reason your lordship's 18, it's difficult, will. Second of April.
Well,